Good afternoon, everyone. I'm Wendy Parmet. I am the faculty director for the Center of Health Policy Law at Northeastern University School of Law. And I want to thank everyone for joining us today at this live stream version of our annual Health Law Conference, Public Health Litigation, Possibilities and Pitfalls. This is hosted in collaboration with the Center for Health Policy and Law at Northeastern University and the Northeastern University Law Review. Every year, the center hosts a Springs Conference focused on a relevant topic in health law and public health law. This year, of course, all of our plans have changed due to COVID-19. We hope that everyone is staying healthy and staying at home. And we want to thank all of the healthcare workers and other essential workers who continue to face the challenge of working every day through this virus, in spite of everything that has transpired in the last few months. We thought it was important to continue to engage with the community in a meaningful way and to bring together experts to discuss issues that are important to public health. And I should say public health law now feels more important than ever. More than ever, we feel a pressing need to highlight the important contributions of public health law scholars and experts. And we're very grateful that they are able, despite all the difficult circumstances, to present their papers to us today. And we are also very grateful to the commentators who are also sharing their time and expertise with them today. Through the next 3 hours, you will hear from scholars and experts as they present their latest research and offer a commentary on a variety of topics, including public health litigation transparency, the Second Amendment and gun violence, the opioid crisis, tobacco and e-cigarette litigation, and many other important topics. Our goal is to explore the possibilities and pitfalls of litigating these public health issues and the ways in which such litigation has led or not led to improvements in the public's health. Before we begin introducing our speakers, I first want to thank my dear colleague and our managing director, Jennifer Ewer, who, despite every pitfall that we have thrown at her and that nature has thrown at her, has managed to put together this live virtual symposium. It's not what we were anticipating, but thanks to Jennifer's hard work and incredible energy, we are able to present to you today. And now I'd like to introduce Kelly Canapari, the editor-in-chief of the Northeastern University Law Review, who will tell you more about the collaboration between our two organizations and introduce our speakers. Thank you, Kelly.
Apologies, I believe I was still muted. Thank you very much. Hello, I'm Sarah Kelly Canapari, and I'm the editor-in-chief of the Northeastern University Law Review. The Law Review is published twice a year and engages a diverse range of topics in legal scholarship, with a special focus on articles that connect public interest, innovation, and practical application of the law. This year, the Law Review is proud to celebrate its third annual collaboration with the Center for Health Policy and the Law. Specifically, we worked alongside the center to announce a call for papers, select authors, and host the symposium. The research presented during this event will be published in Volume 1 of this year's Law Review. In addition, we partner with the center to continue engaging with speakers after the annual event through a blog symposium, which is co-hosted with the Law Review's online forum. I invite you to visit our website and read pieces from last year's blog symposium entitled Promises and Perils of Emerging Health Innovations. The blog symposium provides a post-conference platform for panelists to share short pieces related to their presentations and addressing a number of healthcare-related topics, such as prescription drug monitoring, human genome mapping, health privacy, and the accessibility of health information. We look forward to our continued partnership in providing high-quality, diverse content in pursuit of promoting health and public interest on a global scale. Now, I will hand things over to Jennifer Ewer, Managing Director of the Center for Health Policy and Law, who will moderate the speaker sessions. Thank you.
Jennifer, you're on mute.
Can you guys hear me?
Yes.
Okay, good. Jennifer, I apologize. I did not hear anything that you said on my end, and I'm sure that that's my fault. Thank you guys for having me. I'd like to start out by thanking Jennifer for the fabulous job that she's done and gentle hounding of me that I have well earned for getting my stuff in. Donna, thank you. I know that I shortchanged you here with my short piece, as I have been very detained and distracted in New Jersey. I'm the only person at the Health Law Center at Seton Hall that teaches FDA law in a life sciences state hub that is New Jersey, that is being devastated right now by this crisis. And excuses aside, it's been a terribly troubling time for us. And I hope you all do keep the folks in New Jersey in your thoughts right now. Hopefully we're going to be turning the corner here soon, but it has been a tough 2 months for us in New Jersey. I'd like to thank Wendy and Richard for being an inspiration for me on this piece. I was very focused on this topic before the COVID crisis because this has been my research area for about 18 months to 2 years, particularly with the opioid litigation. So it's actually been rewarding to me to be able to get back to this and sort of distract myself from like I said, what's the situation on the ground here in New Jersey. So thank you so much, Don. I appreciate it. I'm going to try to keep my remarks short because I would much prefer to hear your thoughts. And as you know, the upshot of not having completely built this out yet is that I am completely open to feedback and very willing to take it today because it's going to do nothing but help me over the next month or two while I build this out. So here's what I'm going to do real quick. I'm going to tell you my thesis. I'm going to tell you about sort of how I'm thinking about the sections and what my inspiration for this piece is. I'm going to talk about my 5-point framework about why transparency is the most important public health good that comes from civil litigation. And then sort of engage with you guys about different policy proposals, rules proposals that might help here. And that's really kind of part of the struggle of the article because really the law is in place and the courts simply aren't following it, at least in the MDL process that I talked about in my opioid piece. And I'd love to get feedback on that. So the most important, my thesis is very straightforward. I'm a very nuanced person, as everyone knows is not true, that knows me. It's simply this: the most important social good advanced by public health litigation is transparency. Rampant secrecy has become the norm in complex civil litigation. It's under threat of extinction because of the sort of evisceration of the class action device, the interpretation of the ruleslessness of the federal rules of civil procedure. Secrecy norms are incentivized by the MDL and binding arbitration things that dominate the landscape. And this is an enormous threat to public health and safety. That's my thesis. My inspiration for the piece was sort of driven by about 4 things. First, not surprisingly, Professor Parmet and Danyard's article, The New Public Health Litigation, one of my all-time favorite pieces, which was published in the Annual Review of Public Health in 2000. If you haven't read it, I strongly recommend it to you. It's sort of been a driving force for me in this sort of transparency realm in which I found myself entangled. I doubt I'll do their article justice, but my piece imagines itself, at least in the front end, as a reflective retrospective about the important ideas that they explored 20 years ago. In that article, Wendy and Richard query the value of litigation as a public health promoting tool by examining the then new litigation reform movements of big tobacco cessation, gun control, lead paint litigation, and HIV advocacy, among other things. They make myriad important observations about the importance of public health litigation throughout the article, but the one that I cling to and hone in on in my article, unsurprisingly, is about public health litigation's very important role as a transparency promoting tool. Specifically, they point out that public health litigation has the ability to expose, quotes unquote, corporate wrongdoing and regulatory failure through the civil discovery process, and thereby, quote, change the political climate in which the issues of public health law are debated. Second, my article was informed by my pre-COVID research focus, which aimed to expose and critique the insidious secrecy that was dominating the opioid multi-district litigation, which has been and continues to be litigated in the Northern District of Ohio under Judge Polster. I wrote an article examining that horrific situation called Opioid Multi-District Litigation that the Ohio State Law Journal was generous enough to publish. It examines the super secret nature of that litigation and challenges Judge Polster's absurd non-transparency rulings, which were, by the way, provoked and litigated all the way to the Sixth Circuit, where they were vindicated by the Washington Post and a very small newspaper that is on the threat of collapse in my former home state of West Virginia, the Charleston Gazette, which brought light to these proceedings. Not only was the ARCOS data or the opioid pill distribution data being obscured from the public and the news media in that litigation, virtually every single thing that had been filed in that case, including First Amendment complaints, Second Amendment complaints, motions, have been filed redacted or under seal. Third, while I was working on edits on my article last summer, Reuters in July published an investigative report which targeted mass secrecy in public health litigation. And I'll bring up the Reuters report later in my discussion, but at this time, I just want to let you know, and I'm happy to send the link on this. Reuters went in and did an analysis of about 3.2 million federal lawsuits filed between 2006 and 2016. And they crunched the data, and you can see all their charts on their website. And what they found was that judges allowed litigants to seal materials in at least 65% of products liability actions. And over the last 20 years, since Richard and Wendy wrote their piece, judges have sealed evidence relevant to public health and safety. This is a quote. Over the past 20 years, judges have sealed evidence relevant to public health and safety and about half of the 115 biggest defective products cases. They went on to say, which I pointed out in my last article, quotes unquote, and 85% of the cases where public health and safety information was under seal, judges provided no explanation for allowing this secrecy. And as I argue, that's a blatant violation of Rule 26 of the Federal Rules of Civil Procedure. Fourth and finally, my article is informed by the recent work of both public health law and complex litigation scholars. While working on the opioid MDL litigation piece, I read two books that I highly recommend to you about complex litigation. One, Professor Alexandra Lovett's 2017 book called In Praise of Litigation, and Professor Elizabeth Chamblee Birch's 2019 Tour de Force, my book of the year, Mass Tort Deals, Backroom Bargaining, and Multi-District Litigation. Lava contends in her book that civil litigation helps promote democracy functioning norms, and I think that's incredibly important. She lists four of them: helps enforce the law, it helps foster transparency by revealing crucial information to the public. It promotes participation in self-government, and it offers a form of social equality by allowing litigants equal opportunity to speak and be heard. I think all those things are important, but again, my focus here is on transparency. So I pick up on her chapter on that and talk about it in the article, which I need to expand on. And Donna will certainly mention that, I'm sure. So I draw on some of her narratives. Elizabeth Birch's book is in a different form. What she does is expose the numerous problematic litigation processes that have evolved around MDLs that incentivize secrecy, incentivize fast, secret, under seal settlements and pleadings because by the judge, by the plaintiff's attorneys, and by defense attorneys, all at the expense of public health transparency, and often one could argue plaintiffs. Supreme Court case law and amendments to the FRCPs that have taken place over the last 20 years since Wendy and Richard wrote their terrific article have ensured the preference of MDLs and binding class arbitration proceedings that are riddled in secrecy at the expense of the class action device as ways to bring these claims. And Professor Birch's book is incredibly helpful. Finally, last shout out, I draw on the public health scholarship, and I think this is really important, that examines public health's litigation's important role in disrupting prevailing and problematic narratives about disease etiology and that drive public health policy. This is a really important point. One example, if you folks want to read, Professor Lindsay Wiley at American University has a fabulous article called Rethinking the New Public Health in 2012, where she observed that public health litigation has had an important role in shifting public narratives away from blame, blaming the victim, behavioral models of public health. This was big tobacco's big win for years and years and years against individual litigants. You chose to smoke. They used consent defenses and the like to sort of promote that. It was very successful. The tort reform movement picked up on that and really ran with it. And one of Lindsay's really important points here is that we have public health litigation has helped us relook at this and move on to an ecological model that looks at structural determinants of health and is really sort of replacing this behavioral model in the sort of public narrative. And the opioid litigation is responsible for some of that as well. So my paper starts off by revisiting and expanding on Wendy and Richard's article, talking about the new public health litigation. What I do at the beginning is talk about the longstanding common law and constitutional doctrines that serve to undermine a sort of strategic approach to this litigation for any number of years in the 20th century. And some of the things I talk about there is sort of the Lochner era decisions really briefly, and these blame shifting defenses and the common law of torts that were extremely successful for big tobacco and lead paint later on, assumption of the risk, consent, contributory negligence, and those sorts of things. So I sort of expose that. Then I sort of, the one happy part of the paper goes to this, like, look at the success of the parents patriae litigation, at least so far as transparency is concerned. The states and municipalities bringing this litigation about against big tobacco and the like, and evolving new legal norms and sort of finding a way around some of these defenses, because you can't blame shift back to the state or the municipality. So it was a very crafty way around some of these common law tort and procedural problems that were sort of standing in the way of this litigation. So I talk a lot there about the tobacco litigation, et cetera, and I'm going to expand on that. The next section of the paper I think is really important, and it's about this look back at the last 20 years where we've had this ferocious backlash, big success from the tort reform movement, and amendments and court decisions that really facilitate this kind of rollback of rights and remedies for public health litigants. Borrowing a page from big tobacco's early blame shifting litigation strategy, the tort reformers, depicted the American civil litigation as an American tort monster that promised to devour corporate profits and thereby instigate the downfall of America. This is quite successful. I'm going to highlight some really interesting ads that were run during that time as I build out this paper. And then I go on to argue the federal courts really, served as formidable allies to the tort retrenchment movement and the strategic litigation counter-revolution, as I call it, by rolling back any number of rights and remedies. And I sort of quickly hit the notice pleading requirements. Everybody knows the Rule 8 cases, Twombly and Ashcroft, or Iqbal, which obstruct access to judicial fora, narrow justiciability rules in recent standing cases. They expand the preemption and commercial speech doctrines. I'm particularly sensitive to this in FDA law. They have restricted the ability to file class actions through not only federal legislation, but also amendments of the civil procedure rules, and their strong protection of binding arbitration in virtually any context. So again, there I'm going to talk about court rulings as sort of Supreme Court case law, federal case law that has sort of really bolstered this counter-revolution against the successes that were made in the tobacco litigation movement. And what is discussed the least in this literature that I'm working on now, because I've got to do this entirely myself as a general rule, there's a few people that have touched on it, are the sort of very shady secret amendments that have been made over time to the federal rules of civil procedure that have also facilitated this. And there was direct lobbying to the Rules Advisory Committee. There was some really shady things that went on here. So again, this section is kind of depressing because it's about a 40-year look back at the demise of strategic public health litigation through this very well-funded corporate PR movement, tort reform. So when I get through that, the third section of the paper focuses on the rise of anti-transparency norms in strategic litigation that kind of parallel these changes in procedure and substantive tort law that I go on about in section 2. This is the part of the paper that I got to build out a little bit. Class actions are being replaced again by MDL. This section, what I think I'm going to focus on right now, and like I said, I'm open to discussion, is MDLs, binding arbitration first, then MDLs, the MDL processes and procedures, and then use the opioid litigation again as an example, simply because I've done a pretty deep dive on that on my prior work, but I'm open to including anything else. So coming back to Judge Polster again in that one, I'm going to be really really, really popular with him by the time all this is over with. The fourth and final section of the paper is dedicated to explaining the importance of transparency in public health litigation. I have 5 reasons why I think this is important, and then I give examples. Number 1, the public has a compelling interest in transparency in health and safety litigation. This notion is not new. It's not novel. It's old as the English common law. It's a bedrock attribute of the Anglo-American justice system, and it derives its roots from not only constitutional law, but common law procedures that the public has the right to access the courts. There is tremendous language in the tobacco litigation cases in the Sixth Circuit around this, and that's a very easy argument for me to make, and I start out with that. I then say that public transparency provides an important check on pro-secrecy and the pro-settlement forces that drive most of the parties in the MDL proceedings. This subsection explains how the MDL processes and procedures incentivize all players to engage in litigation secrecy with the aim and goal of reaching a fast, secret global settlement, which virtually always is filed under seal at the expense of public transparency and justice, often, at least for the victim plaintiffs in that litigation. Number 3, transparent discovery is more likely to improve public health policy making than secret proceedings and confidential settlements. I say that the public should advocate for transparent health and safety litigation because history teaches us that it is the disclosure of health crisis provoking and exacerbating facts, and not the settlement funds at the end of the day, that drive meaningful public health reform. And many of you who are on here today have written about this, and I have a lot of literature to draw from here. This is a wonderful section to write, but this is about the tobacco settlement and all the sort of retrospective, wonderful scholarship that's looked back on this and said what was important here was disclosure, creating this document database for people to really realize what was going on. It wasn't the settlement money, which, as I think some of you know, has been written about by other people, but largely was not used for tobacco cessation efforts. And in fact, some states, including the tobacco producing states like North Carolina, actually used the tobacco money to promote tobacco farming, and subsidize tobacco farming. So they literally used, and they propped up tobacco because their payments depended on it. So the settlement, even the basic structure of the settlement was problematic. So the 2 good things that came from that, I guess, state taxing and this just transparency, the theme of the paper. Number 4, lack of transparency in cases involving ongoing public health and safety issues can kill. I kind of go for the juggler here. Don't want to mess around and talk about the Remington 700 litigation. And how this was secret for any number of years. Many children were killed by a faulty trigger safety device on this mechanism. The company knew about this since the mid 1940s. People are still dying from this at the turn of the last century, and this is finally exposed. All this stuff had been filed under seal. Children and adults had died, and this went on for decades and decades and decades. So lack of transparency can kill you. It's number 4. And number 5 is near and dear to my heart, and I think that this is one of the pitfalls of the opioid litigation. I want to do a lot better job in this section. I think I'm going too easy here. I make the argument that transparency in this kind of public health litigation can inform and shift sticky narratives that are problematic. And this is sort of harkening back to Lindsay's piece and saying the blame shifting, what's really going on here, it's much more complex or nuanced. We've got to look at structural problems in the healthcare system. We've got to look at the laws that are encouraging these bad outcomes, and change public health policies and laws around these things. But I do worry, and like I said, I'm going to get ready to turn this over to Donna, who I'm sure has much better things to say about this than me. I do worry about this part of the paper just personally, because one of the things I've been very frustrated about is if I was going to be completely honest with you, the opioid litigation has reinforced a very simple narrative that is really problematic, that is not helping. It has not made the public aware of, and I talk to people all the time and get interviewed by people all the time about this because I've been on top of this litigation. People have not looked at the egregious regulatory failure here from the DEA and FDA, the moves that these agencies have made, which are now creating resource shortages in emergency rooms in the middle of this crisis. All of these policies were so bad that they're now contributing to a secondary crisis that they never imagined. And then none of them are justified by the scientific data or the evidence. Meanwhile, we have people suffering from millions of Americans suffering from chronic pain that have to do contracts and UDTs monthly that can't go in and get their pain medication. Suicides are up. I could go on, and I'm not going to right now. But I am concerned about the strength and weakness of this argument that, you know, Lindsay made. I want to believe I made in my last paper, which is that we can change this. I think that when you have a complex, nuanced public health problem that involves all of these players and all of these actors, that harkens back to 1970 and 1974 litigation and the war on drugs, it's very difficult to shift that in the litigation context, when there's a much easier, you can create the villain of Purdue Pharma and go on with that. And that's a very easy thing for the public to believe. So I'll leave it at that and say that, again, and perhaps this is something I should spend more time on the paper, the simple villain creating tort monster, Purdue Pharma, the Sacklers, this has been very successful in American history, and what the public believes is going on. And I'm concerned that my my argument number 5 is fairly weak. So Donna, I'm going to turn it over to you. Thank you all for listening to me. I hope that that gives a sort of overview about what I'm up to, and I appreciate the opportunity.
Great, well, thank you. Of course, my phone starts ringing when I get on here, so nice to meet you. Thank you for the opportunity to be part of today's forum and to review the manuscript, Jennifer. So I do not feel shortchanged. You'll hear that I really enjoyed the article. I know it's not done yet, but everything I read. But I am neither a litigator or an academic. And the other Jennifer said it doesn't matter, you know, review it from the point of view of someone who practiced as a state public health attorney. So I know you'll get other reviews that are talking to you about doctrinal issues and everything else. So take it for what it's worth and seek other reviewers. So I will say I did go back and I read Wendy and Dick's article, the new public health litigation. And so it just, you know, screams off the page from there that it's clear that transparency is key to the important outcomes that they point to for public health litigation. So they flagged, it focuses attention on the products that endanger the public's health. It alters the public's understanding of industry's role of disease, shifts attitudes and influences and moves the public debate. And then, of course, they note that litigation discovery plays a critical role in disclosing information and education that the public needs about the nature and causes of health risks. So transparency is key. And then I read your article. I did not have time to read what other scholarship may be out there with respect to public health litigation transparency. So that said, I thought your paper was an incredible follow-up to the earlier article. And it just struck me as incredibly informative, well-written. Like I said, I am not a litigator, so some of it was just eye-opening to me, the incentives and the awful betrayal of clients and the public in these critical and what do we call multi-district litigation. So it was really an eye-opener, educating me a lot. And then having now met you versus, you know, on video, I just appreciated how your voice, the author's voice, just comes through. The passion comes through in the article, and outrage at times, which I think is great because it makes it come alive, you know, with occasional language that we've all heard today. So rampant secrecy and blatantly illegal. I just loved it. Fear-mongering public relations machine. You know, as I read it, I have to wonder, you know, if the more academic editors are gonna, you know, swat at that and tone it down, and I hope not. So, and also I thought that where your language was conversational in tone at times, like you ask, you say, if the public's right of access to court proceedings is long-standing, has expanded in scope over time, and appears to be robustly guarded by the federal appellate courts, then why the fuss? And then after some discussion, you say, the fuss in sum is about the rampant secrecy in mass tort litigation, notwithstanding the law, which demonstrates that even well-settled fundamental public rights can suffer substantial erosion if not vigorously defended. So you're bringing the reader right with you, and the uneducated in this sphere reader too. So I think that's really powerful. I had some suggestions, and I realize you outlined in places where you weren't finished yet. So section 2 or B, whatever you're going to call it, I think they're the same thing. On the public health litigation counter revolution, the tort reform, I would have want to see more clarity concerning the significance of this revolution for the non-transparency. So I'm sure that link was coming. So take that with a grain of salt. So then finally, and this may be way off base from going there anyway, there are several discussions in the manuscript about messaging. So you referred to some of them. So the role that messaging played and played well for industry. So you talked about individual choice. Big Tobacco's decision to defend on these responsibility shifting theories was just as politically powerful as it was legally efficacious. That's what you say, and quote from. And the assumption of the risk narrative, individual choice portrayed public health advocates as extremists who support government intrusion into private decision-making. And then the American tort monster, which you have spoken about. And then in section 3, in your article, you say, and I think you referred to this again just now, history teaches that it is the disclosure of health crisis provoking and exacerbating facts and not the award of settlement funds that drive meaningful public health reform. So with that in mind, it made me wonder about the messaging and the positioning of the manuscript for your audience. So, I often think, who's the broader audience? I've got to say, many years at Massachusetts Department of Public Health, how many times did I pick up my head and was able to read, in the journals? It just didn't happen as much. So as much as it should have. So I had a couple of thoughts. Could the title be something along the lines of a call for public health litigation transparency and, making the case? And then, and again, I don't know how this works in the journal academic world, could the introduction to the article possibly include that brief description, a hard-hitting description of the Remington 700 case? So you're starting with a story, which is what we're told over and over again. Right now, it comes really later in the paper, and I think it should be there in all its full horrible glory. But there'd probably be a way to encapsulate it up front. And, it's really your message. You said it just before, lack of transparency can kill you. So I don't have to talk about that litigation, but that's the message of it. It's heartbreaking, it's shocking, and transparency would have saved life and limb. And then, of course, is this not done in academic circles? I do not know. And then one final thought, like I said, I was really educated by this article and angered by the forces at work and how you describe lawyers settling cases unethically, not in their client's interest in the multi-district litigation, and then judges and lawyers, incentivized to work towards expeditious settlements, which not in the public's interest. So I'm really looking forward. I don't think I got the conclusion with your proposals for legislative and regulatory action, right? So, you won me over. I've been a good student with this article. I really appreciate it. And I'm looking forward to, reading your proposals for those reforms.
Thank you, Donna. I really appreciate it.
Okay.
That's great. Thank you so much to both of you. So I didn't realize that I was on mute before, so apologies for that. So I just want to repeat a couple of points before I introduce the next set of speakers and commentators. The first is that because we don't have a traditional Q&A session for this event, we're inviting individuals to tweet their questions or comments for commentators, for speakers, or for the center more generally. So you'll see that some of the introductory slides have the Twitter handles for any speakers that have the Twitters, have Twitter accounts, and you can also tweet the center at Newsel Health using the hashtag NewselHealth20. I also want to mention that the papers that are discussed today during the symposium will be published, as Sarah mentioned earlier, in a later issue of the Law Review. So hopefully you'll keep your eye out for that. We'll also send some notices around and you'll be able to follow up and read the full papers that are discussed today. So we hope you're all excited. Okay, on to paper 2, litigation is education, public health's role in Second Amendment constitutional analysis. Speakers will be Michael Ulrich from Boston University School of Public Health. He's the author, with commentary provided by Zoey Grover from Stop Handgun Violence. So let me invite them to join us.
Great, thank you, Jennifer. Let me just make sure I'm not on mute. Okay. So first, before I get started, I just want to thank Wendy Parmet and Jennifer especially for making the relatively seamless switch to a virtual event. They have been extremely helpful in doing all of this, extremely patient, at least with myself and probably some of the other presenters. And so before I get into the paper, for any students that are watching, I wanted to say how I, at least personally, have struggled, working on this paper and trying to really concentrate during all of this. And so just know that the struggle is real for many of us. And so hopefully that also explains to Zoey why the paper is not quite as fleshed out as I would like it to be. So when thinking about public health litigation, at least for me, my first thought typically is it being used in public health as a regulatory function, as a way to get products to be safer, manufacturers to make them safer, or at least to provide an avenue for liability for harms. But that is, and so I primarily work in Second Amendment. And so thinking about that for Second Amendment and gun violence, though, it's quite limited because there is this federal statute, the Protection of Lawful Commerce in Arms Act, which prevents a vast majority of the ability to sue and hold manufacturers or sellers liable. And so that really limits the ability to act in a regulatory function. So there is a Connecticut case that is moving forward, but that's really focused on marketing. And while I think it's a really interesting case and important to follow, ultimately discovery probably will be the most useful piece of that litigation. And so it wasn't exactly what I wanted to focus on for this. So I was thinking, what other role then can litigation play in terms of public health and gun violence? And the Second Amendment is an interesting area of law because it's a relatively new right and it's relatively undefined. We know from Heller that there is a individual right to keep and bear arms, but it's primarily housed in self-defense. And then Heller really focuses after that on having a handgun in the home. And so what I started thinking about is how Second Amendment litigation has the potential, at least, to act actually as a deregulatory tool. Challenges to gun control laws, if they are struck down through constitutional challenges, then what you could see is a lot of gun control laws around the country being struck down and being undermined in some way. And so that opens the avenue for Second Amendment rights potentially to really be weaponized in a way to counter public health goals. So with this paper, I wanted to think through that a little bit more and to sort of focus on what role then public health could play in those sort of litigations, right? So this is more constitutional litigation than it is liability litigation. And what I was thinking is really litigation opens an avenue for informing and educating the judiciary. The focus primarily often in some of these Second Amendment cases is on the scope of the right. And that's really it. And it's really focused on, okay, is this protected or is it not protected? And that is certainly important to, a constitutional analysis, but so is the state interest in limiting rights. And that's really where public health can come in, right? So when we think about the current epidemic that's happening, there are a number of rights for certainly plenty of people that are being limited in some way. And so it's not simply about the right, but also figuring out and evaluating the balance between the state's interest in limiting rights and when and to what extent that can happen. The other thing that I think public health can do in terms of Second Amendment litigation is provide a broader understanding of what's really at stake and what gun violence really is. Oftentimes gun violence is thought of as, fatalities, right? And certainly that is a problem. There are nearly 40,000 deaths a year, but there are over 100,000 non-fatal deaths. There is trauma to people that are exposed to shootings that aren't technically victims. With growing mass shootings, especially in schools, there are more youth that are afraid and have anxiety about shootings, even though they've never been exposed specifically, right? And so public health can really kind of build out a broader understanding, I think, of what gun violence is, what it can do, and therefore a better understanding of what it is that the state is trying to accomplish. And so the way that I was thinking through how this could be done is through the use of amicus briefs and social science. And so there's a long history of briefs and social science being able to inform and influence judicial outcomes. And this has been especially important in certain areas. So the history of the Supreme Court in particular is that it's predominantly been male and white. And so when you think about cases that involve sex, and particularly the lives of women, race, and then gay rights, and those are sort of three of the areas that I try to focus on in the paper to show, the evolution of the court's understanding of issues in these areas. You can see the influence that briefs and social science have played. So for race, for example, Brown v. Board of Education, there's footnote 11, which is often referred to as, sort of one of the foremost areas where the court has used social science to influence their outcome. There's growing debate over how much the court really relied on that. But even without necessarily relying on it for the outcome, most people think that it at least was included to try to bolster the outcome. And so that still provides some understanding of the court thinking through that, this helps it seem, like the right decision. And then there are more recent cases. So affirmative action, the Grutter case is known as one that was highly influenced by the amicus briefs that came in. In particular, there was a brief from people in the military who said that how important and how important affirmative action was, and having a diverse group of people helped the military achieve their job. And so a lot of the court has said that was really important in their understanding of the role that diversity can play. In terms of sex and women's rights, you think to the Mueller v. Oregon is really where the briefs sort of got their name, the Brandeis brief. Mueller helped the court sort of reverse trend from Lochner, where they saw the Lochner case as simply a right to contract and not really a public health issue in terms of limiting the hours that bakers could work. Whereas, just a few short years later, limiting women's ability to work a certain number of hours it was really heavily focused, that Brandeis brief, on the harms that could potentially come. There's a lot of sort of sex stereotypes built in there. But again, you can see the influence that the brief had. But moving forward, you can also look at more current cases like Gonzalez v. Carhart, one of the abortion cases, where there was a brief that talked about the regret that women had that had abortions. And that actually makes it into the majority opinion, where it says that there's no empirical data to support this. There is concern that women might come to regret their decisions. And that's something that, should be taken into consideration. And so you look at that as compared to a few years later in Whole Women's Health, where, the court starts to look at it in a different way. In that case, Texas was using abortion provider restrictions, in essence, to say this is about providing health, improving and protecting the health and safety of women who decide to undergo abortions. And the court, rather than say, okay, we're just going to take you at your word that that might improve health, really went through and looked into the data to see, okay, is there any improvement, right? And so really evaluated the benefits that were claimed and didn't find any, and instead found significant burden. And one of the other things that countered the brief that was used in the Carhart case was a brief by women, specifically in the legal arena, who said, I have had an abortion and it helped me get to where I am. It was important for me, and my life would be different if I had had that. And so people, observers have said that that was also probably very influential on the court, because these are women that they have co-clerked with, that have presented arguments before them at the court. And so, these are people in their own field, people that they know. And so it makes it a little bit more tangible. And then finally, in the area of gay rights, right, we think about the Bowers case in the 80s, where Justice Powell largely thought to cast the deciding vote, limiting gay rights or the evolution of gay rights, famously said that he didn't think he knew anybody who was homosexual. Turns out that one of his clerks that term actually was gay. And so, the limited understanding of the court in that case, as compared to the Lawrence v. Texas case, where there were briefs, Harold Coe in particular wrote one saying, look, a lot of the information that Bowers was based on is actually faulty, right? That it is a lot of stereotypes and assumptions and isn't truly accurate. And so again, you can see sort of this evolution that occurs. And so, that again leads into, okay, so what's public health's role potentially then in litigation for Second Amendment rights and the fight against gun violence? And in particular, federal judges have said in surveys that the things that are extremely beneficial, or that they find to be beneficial through briefs, are both legal arguments that aren't being necessarily made in the party's briefing, and to provide a broader view of the impact that the case and the ultimate outcome can have. And this is where I think in particular, public health can really be beneficial. Public health and public health law is about identifying risk, and identifying risk that is amenable to government action to minimize that risk. And so in that sense, it shows that, one, no right is absolute. And so limiting Second Amendment rights is no different than any other area of law. And two, it again highlights that there are areas and times where rights, even fundamental constitutional rights, can be limited for protection of the public. And so it's really, again, about identifying when and to what extent those rights can be limited. And so I think public health can play an important role. If you look again at a lot of the discussion and debate around Second Amendment rights, their focus is almost entirely on the right itself, which is extremely problematic because it doesn't provide that balance that's necessary. Another thing is that they typically use the First Amendment to analogize, because again, Second Amendment jurisprudence is quite shallow and relatively new. And so they try to look to another more established area and First Amendment is often where people land. But First Amendment speech rights in particular is the focus usually on those analogies, has also been weaponized, right? Justice Kagan said that in a recent case. And so that presents potentially some problems, right? Because if you're analogizing to this area of law that's now being weaponized, it opens the door for Second Amendment rights to be weaponized as well. And then also a lot of the focus in Second Amendment arena is on history and finding historical analogs. And I think that public health law in particular can sort of emphasize, one, the foundational nature of police powers and protecting the public that have been around since before the founding, and the manner in which the state's ability to respond to public health problems evolves over time. And so I think really empirical evidence is going to be particularly important. It's used inconsistently when you look at areas like more guns, less crime, that theory, mental illness, and limiting those rights, despite the fact that evidence shows that they're no more likely to be violent. And so since my time is wrapping up, I'll just say that I think this is really where public health can play an important role in educating the judiciary, again, on the broader impact that deregulating and knocking out a lot of these laws that are in place around the country could have, as well as understanding better the state's ability to act to protect the public under police powers. Right. Thank you.
Okay, I think I'm live. So first of all, thank you so much for inviting me to this event today. And thank you, Michael, for your paper. I thought it was great. I'd like to start just by telling everybody a little bit about me and my organization. My name is Zoey Grover, and I'm the executive director of Stop Handgun Violence, which is a 25-year-old Massachusetts-based organization that works on gun violence prevention. And so in that role, our organization has worked to pass some of the strongest gun laws in the country. And, Massachusetts has registration and licensing. They have, and police discretion for issuing those licenses. They have child access prevention laws, an extreme risk protection order. They have gun dealer licensing. They've closed the boyfriend loophole, which allows, expands the number of people who are prevented from getting a firearm after a domestic abuse incident. We have universal background checks and permit to purchase, and we ban bump stocks, and just a litany of laws to protect us here in Massachusetts. So I live and breathe gun violence prevention every single day. And, I know 100 people are killed every day by guns. 4 of them are children, 200 are shot every day and live. 17 of those are children. 40,000 people die every year. And because I live and breathe this, and I, got into this work because I got into this work after Sandy Hook, but I also lived in New Orleans for 3 years and was shot at on 2 different occasions, just in the wrong place at the wrong time. And I had a friend who died by a firearm suicide. So I have lived and breathed this work, and I care so much about this work. And I forget that not everybody lives and breathes this work and is as educated on the issue as I am. And so that was, I would say, my first takeaway from Michael's paper is just a reminder to myself that not everybody is as educated, and that this is an opportunity to educate more people about the issue of gun violence and about the human cost. And so, I appreciated the fact that Michael kind of talked through in his first section, PLACA litigation and how that has affected, how PLACA litigation has, groups like mine and other gun violence prevention groups like Brady, they've been able to kind of test the limits of PLACA, and they're doing that through cases like the ones in his brief. But I read just yesterday that there's a case in the federal court that is a wrongful death claim out of the Vegas shooting that was allowed to proceed, although it has a question that's being certified to the Nevada Supreme Court. So, you know, I think groups like mine, we look at PLACA as being our opportunity for litigation. But as Michael said, we're hitting a lot of roadblocks, and we're also, it's not moving the issue forward as much as we'd like. We are scared of Second Amendment cases. And just like Michael said, we're afraid that it's going to be weaponized, and that it is being weaponized. And it's unfortunate that most of the cases that are brought to challenge gun laws are again weaponizing the Second Amendment and actually ending up in the repeal of gun regulation laws that my organization fights for. So I thought that Michael is spot on with his suggestion and urging of amicus briefs. My organization has worked several times on filing amicus briefs. We work with pro bono attorneys to put that information out there. We worked with, recently we wrote one for police discretion for issuing licenses in Massachusetts. And that one, the police discretion was upheld. That was a few years ago. And then also we wrote an amicus brief in defense of upholding the copycat provision for the assault weapon ban in Massachusetts. And again, you know, we hear what you're saying, and we think that that's right, that is a role for us to play and a role for other organizations to play in Second Amendment litigation. But I think one of the interesting things I thought about when I was reading your brief was that in PLACA litigation, we have this opportunity to share the stories of victims and survivors that are meaningful stories and influential. And so we don't always win, but these are these sympathetic plaintiffs that I'm sure, you know, help influence this litigation. And unfortunately, the folks that are trying to repeal the gun laws I'm working to pass, they are also having this opportunity to have their sympathetic plaintiffs. And it's unfortunate that those sympathetic plaintiffs are setting the tone for a 40,000 people lost lives epidemic every year. So, you know, I think that idea of storytelling being brought into the court, it's just so unfortunate that the people who get to tell their stories and the people who are the primary plaintiffs in these cases are the stories that aren't the majority of the stories, right? The majority of the stories are folks who've lost their lives and you know, are victims and survivors, rather than the person who is potentially, you know, a veteran with a 20-year-old domestic violence incident where there was no conviction, and they're saying he's a veteran, he's a great guy, you know, and he's the person whose story is told rather than the other people. So anyway, I really appreciated your paper, and I thought it was a excellent reminder that of the work we do. It is so important to be filing those amicus briefs, and it is so important to be bringing those other stories into litigation. And I also appreciated the review of the PLACA cases, because there was at least one of them I hadn't read before, so it was really helpful. And then I'm running out of time, so just as a final thing, I was wondering if I could ask you a question, Michael, and maybe you do or do not have an answer for that, but what opportunities do you see for groups like mine to litigate Second Amendment issues proactively rather than reactively?
Yeah, it's a really good question. It's something that I've started to think about more. So one of the projects that I'm hoping to get into next is looking at so one of the things I'm working on is the constitutional analysis of public carry laws, the right to carry firearms in public, whether concealed or open. And one of the things I'm curious about is whether there is any heightened sense or heightened levels of either mental health disorders or stress or anxiety, and the influence that those laws might have on the public more broadly. And whether that's constitutionally relevant, right? Whether that is something that, can a student who doesn't carry a firearm, but, goes to a school that allows carrying firearms on campus, could they bring a claim, right? Either against the school or maybe against the state because of the anxiety they feel or the fear. I don't know, because it's something I just sort of have thought of recently and haven't really looked through. But I think that's one of the areas it raises the question of to what extent can states be proactive? And I think states can be proactive in terms of regulation, but in terms of litigation, it's something that I've really only started thinking about, honestly, relatively recently. But I think public carry in particular presents a potential area, at least. So.
Awesome. Thank you so much.
Sure. No, thank you. I really appreciate all your feedback and help.
Thanks.
Thank you to you both. That was great. So next up for paper 3, the biggest agency problem of all, public health in opioid litigation. We have Daniel Aaron presenting his research. He's from Harvard University. And offering commentary will be Professor Richard Daynard from Northeastern University School of Law and the Public Health Advocacy Institute.
Okay, hi everybody. Can you hear me?
Yes, we can.
Awesome. I'm so grateful to be here. Thank you to Jennifer Hewer and to Wendy Parmet for setting up this conference amidst a crisis. It's very impressive. And thank you to Professor Daynard for giving commentary on my paper and on my research. Okay. Okay, so I'll be talking about what I perceive as the biggest agency problem in the opioid litigation, which is public health. And an agency problem is basically when you have an agent who's supposed to represent you, and the problem is in that they're not representing you properly. I am at Harvard Law School and Boston University School of Medicine getting a JD/MD, and my graduation is in about 8 minutes, which I am missing, sadly. But anyway, so also thank you to the Petrie Flom Center for supporting this research. So a little background on the opioid crisis. So it led to 47,000 overdose deaths in 2018. If you look at the last 2 decades, it's more like 450,000 deaths. And research has shown that this is an undercount, and plus I'm missing 2 years. There is frequent misuse of opioids, including prescription opioids to this day. So for example, about 4% of the population misuses an opioid each year, and the same is true for a prescription opioid. So these continue to be heavily misused. Here is a chart with the rising opioid prescriptions by year. Many of you have seen this kind of chart. Around 1999, give or take, is when the opioid crisis began. And we've also seen a rise in overdose deaths, which is why we have the crisis. And most of these are due to opioids. There was a lot of corporate misconduct involved in the opioid crisis. I'm going to skip through this because I don't have enough time, but it could definitely fill an entire talk. Also, I want to note that according to Rebecca Haffagee and Michelle Mello and a lot of research, the majority of persons with opioid addiction started with prescribed painkillers. and that's true for even people who use illicit opioids today. So the role of prescription opioids is very important. A little background on the opioid litigation. So the litigation started in the early 2000s where there were opioid victims and an effort to vindicate claims on their behalf in courts. But this litigation was mostly unsuccessful. However, claims continued to be brought. And in 2017, there was a recognition that it was time to start consolidating cases because there were so many. And so in Cleveland, Ohio, there was a multi-district litigation formed, which at first involved 64 cases, although it quickly grew to more than 2,000 cases, many by governments. This is Judge Daniel Aaron Polster, who oversees MDL 2804, which is an opioid litigation. I would like to joke that he stole my name. I'm Daniel Aaron, although I was born later, so maybe that's impossible. The MDL is approaching 2.5 years. There have been no trials. 2 bellwether cases brought by 2 Ohio counties settled. So it's been a little bit of a slog. And so the main question again is agency problems. So is public health adequately represented? And then furthermore, should it be? And I'm going to argue that it should be represented. And that should be obvious to some of you. Others, some scholars have disputed that litigation is an appropriate avenue to pursue public health. But I'm going to argue that this relationship is very strong and that it has implications for how we should go about the litigation. So pardon my silly animation, trying to improve my tech skills on PowerPoint. So step 1, I want to define public health as far as this relationship goes. Then I want to examine the agency problems. So I want to clarify the duty to public health. I want to show that there's a failure to further this duty in the litigation. And then I want to go over what public health would want if it were like a human saying, this is what I want from the litigation. So this is the outline. So let's define public health. So I argue here for a broad conception of public health. So most of the scholarship tends to talk about people with opioid addiction, and that's also been the focus of the litigation. And of course, that sounds like it makes sense, but I'm going to argue that it might be wiser or it might be justified to talk about how everybody in the US is affected by the opioid litigation. So I'm going to be clear that when I speak about public health, I mean a broad scope across people. And I also mean a broad scope across time. This is also trying to improve my tech diagram skills with a 3D pyramid chart. So basically looking into the future with public health as well, rather than just considering people who suffered from opioid addiction in the past. And I'll explain why I think this concept is warranted, a broad conception across people and time. So let's talk about the duty to this broad conception of public health. So I have 3 arguments, which is 1, this is what I think one would come to with the public health understanding of the opioid crisis. 2, the litigation's players are connected to the public as a whole and to public health. And 3, ongoing legal scholarship has eroded the public-private distinction. So one question I want to ask is, can we add people who misuse stimulants to beneficiaries of the litigation? And a few scholars have talked about this. And I want to flag that stimulant addiction and deaths are becoming a bigger problem now, and they're following a similar pattern to opioids. So for example, here's an article, US drug deaths dipped in 2018, but cocaine and meth overdoses rose. And some have even suggested that this is all one epidemic, one larger epidemic of drug overdoses. And perhaps stimulants are wave 4. And then those of you who are familiar with the opioid crisis are aware that there are 3 waves. So question, why can't we apply funds or relief to other kinds of victims, especially when stimulants are also heavily marketed, commonly diverted, and follow a similar pattern? And then furthermore, anybody theoretically is at risk. If your appendix bursts tomorrow and then you're in the emergency department, you may be given opioids, and the way that those are used and prescribed could affect your risk for addiction. So I think that the public has a stake in the way that the litigation is handled. Furthermore, the litigation's players are connected to public health. And I want to argue that only some of these connections need to be persuasive to you to establish this strong agency tie between public health and the litigation. So government-wise, we have most state attorneys general suing. They have strong independent authority, and historically speaking, after the Reagan era, when there was big deregulation of the federal government, a lot of this regulation devolved onto state attorneys general, who now conduct rulemaking, although largely they regulate through litigation. And even the Supreme Court has endorsed health as a valid goal of attorneys general. And collectively, they represent most of the public. Local governments, too, have an acknowledged historical role in public health. Many of their ex-ante regulations are blocked by something called the new preemption, which is a longer conversation. But ultimately, local governments are, not surprisingly, turning to litigation to vindicate their areas' public health concern. Furthermore, there's a new civil procedure mechanism in this MDL that was just invented for it, called the negotiation class, which basically certifies all cities and counties across the country into one class for negotiation purposes. Although a few places have opted out, it represents most of the public. Plaintiffs and their attorneys, too, are tied to public health. So all private lawsuits serve a public function, whether it's compensation or deterrence. The causes of action brought here are very public oriented. I don't have time to go into that, but public nuisance, RICO, the Controlled Substances Act are all public oriented. And then a lot of plaintiffs' counsel are serving in lead counsel roles, where they're basically serving in roles that protect other people beyond their clients. And so I would argue that there is a tie to public health there. Even defendants, are corporations made to pursue the bottom line, or should they consider other interests? Should public health duties be outsourced fully to regulators? And I would argue that it's in our interest to have corporations consider other goals. Why not have a corporation that considers the ramifications of its actions when it's marketing a product? And then furthermore, corporations themselves have often acknowledged that they have a duty to health and to society, as this business roundtable statement showed. And we have multiple defendants in the opioid litigation signing that statement, showing that even some of them acknowledge this duty. So to summarize that, litigation's players are connected to public health. Lastly, we have erosion of the public-private distinction. This is kind of a complex legal theory argument, but basically scholars and attorneys are attacking the litigation for being too public or also too private and not representing the public interest. And a lot of these arguments are contradictory. And I just want to point out public and private are a little bit nebulous. And according to William Rubenstein, both public and private lawyers pursue both deterrence and compensation. So this is kind of the public-private distinction is a little bit weak. And then furthermore, tort law, which is often called something private, is publicly administered, has public actors throughout. The standards of conduct are established usually by the legislature. And so ultimately, tort law is kind of a form of social policy. So I think that the connection to public health is pretty strong. Again, for those of you who already acknowledge that, fine, but some don't. And also, I want to reiterate that this is the broad conception of public health that I'm trying to argue. And since tort law is a social policy created for society, it should benefit society as a whole. Furthermore, there's a failure to further this duty, thus presenting the agency problem. So Judge Polster, as I've mentioned, this also connects to Jen Oliva's fabulous talk earlier. He's expressed favoritism towards settlement and has a pretty small litigation track. It doesn't seem to be a priority. And if you look at what he said in the transcripts, people aren't interested in deposition and discovery and trials. My objective is to do something meaningful to abate this crisis and to do it in 2018. It didn't end up panning out, but what he wanted to do was settle the case really fast. Furthermore, the negotiation class that I mentioned is exclusively designed to produce a monetary settlement. It does not have a mechanism for public health. It does not have a mechanism for transparency, for example, and that goes back to what Jen Oliva was saying about transparency being essential. It seems like the goal is to have a settlement. And then there's a longer conversation about why federal courts and MDLs in general are geared toward settlement and fast settlement at that. Elizabeth Jambley Birch's book, Mass Tort Deals, went into this extensively. And then even the manual for complex litigation tells judges, such as Judge Polster, to settle their cases. So this incentive is baked throughout. And then plaintiffs and defendants attorneys, I feel like I'm copying Jen Oliva a lot. Oh, one sec. Okay, so I'm going to skip ahead a little bit because I think Jen Oliva mentioned this. But basically, there's a lot of incentive toward efficiency, settlement, and fast money. And thus, public health is then implicitly secondary. So goals. What would public health want if it were represented? I'm going to focus on accountability today for time reasons. So families continue to say that they want Purdue Pharma to be held accountable, and the majority of the public thinks that opioid companies should be held accountable. Nicholas Terry, who wrote a really great article on the opioid crisis called the MDL Litigation Unicorn, says that accountability is tied to strong, retributive, and deterrent motives, and he frames it as emotional. On the other hand, Attorney General of Massachusetts, Maura Healey, rejected an opioid settlement because it doesn't provide accountability and transparency. So what is accountability, and is this a useful goal? Administrative agencies are a really great example to look at accountability because this is a very hot topic. The criticism is that agencies possess wide discretion and do not have to answer to the people. This is, so the Government Accountability Office is fairly new as of 2004. It used to be called the General Accounting Office, and that shows how hot of a topic this is. So here's a good definition of accountability related to agencies. You set a standard, you monitor the agency's activity for conformity with that standard, and if they don't meet the standard, then you apply sanctions to the agency. Now, it's funny because this actually sounds exactly like tort law. You set a standard, you monitor for conformity, and if it's not met, you apply sanctions. And actually, this isn't really a novel idea. Tort law has been described, my chat is blowing up right now. Tort law has been described as having an accountability function. And it's funny that this has been occluded and not prioritized. So agency accountability is necessary for keeping agencies in check, fundamental to democracy, legally interesting, according to the literature. Tort accountability is unnecessary, emotional, retributive, often emotive. Not everybody thinks this, but it's interesting nonetheless that this is in my opinion, a little bit of a double standard. I'm going to skip ahead for time reasons. But the main idea is that the sanctions are supposed to stop this conduct from occurring in the future. So now the tort law can provide a new ex ante incentive for future public health litigation by applying sanctions strong enough such that defendants, were they subject to those sanctions, would not engage in that conduct. And so for time reasons, I'm just going to skip ahead to my solution, which is mass disaggregation. And there are a lot of pros to this. The MDL was supposed to be for pretrial motions anyway. But ultimately, I think if you disaggregate the litigation, you'd get a lot of trials across the country. There would be higher judgment amounts. And then furthermore, the courts could pierce the corporate veil to provide higher judgments for plaintiffs. And therefore, actually, there might be higher returns in the long run, and there would be accountability. And so that's it.
Okay, I think I'm supposed to start at some point. Can you hear me?
Yes.
Okay, well, if you can hear me, I'm going to work on the assumption everybody else can too. Let me begin, Dan, by being the very first person to congratulate you on your graduation.
Thank you so much.
Right, it's rare that I get the opportunity to say that. Secondly, this was a great paper. It's deep. It's really broad, thought-provoking, really exciting paper. I have one disagreement with you and Jennifer, and it's about Judge Polster, whom I've never met, but one of the things he said, in addition to wanting to settle the case, is he also said that he didn't want the settlement to be just about money, that he wanted to actually do something about the problem. So I think that he's actually maybe, at least in my mind, he's a more sympathetic character vis-a-vis the public health. And in fact, we proceeded to, we being 6 public health organizations, including 3 of them that I have some participation in, the Northeastern Center for Health Law and Policy, the Public Health Advocacy Institute, and the Public Health Law Watch, along with 3 other organizations that I think are also represented on the panel today, filed an amicus brief seeking public health relief there. And we'll see what happens with it. But we propose the creation of a nonprofit foundation to monitor the implementation of the settlement, participate in implementing programmatic initiatives, and administering a funding mechanism to encourage the best use of resources for treatment and prevention at the community level. So, we're and I saw this as invited by Judge Polster. I have no idea what effect it will have, other than to the extent that Judge Polster has to give his blessing to some kind of settlement. And obviously Purdue is now out of this because they're in bankruptcy court. But to the extent that he's still involved, I would hope that this will exercise some constraint on plaintiffs coming in with a purely monetary request, a purely monetary settlement, a settlement that simply moves money, which is what Judge Polster said he was not looking for. Let me just say a few things that are go on that are not specific to your, beginning to the details of your paper. I want to begin by just describing for people what an agency problem is. I'm not sure everybody understands that phrase. It basically, the paradigm case for this court, and the one where it was most developed and talked about, was critiques of corporate governance. And the notion was that corporate managers, the officers of corporations, were supposed to be running the corporation for the benefit of the shareholders. And the critique was that, in fact, they were running it to have a comfortable life, and they weren't taking the kinds of risks that the shareholders would want them to take that would result in the shares in stock going, way up, hopefully, because they were doing just fine, thank you, and why rock the boat? So that critique led to a series of, and that was sort of as an agency problem. They're agents of the shareholders, and they're not doing their job because they're in a position to define what their job is, and a whole bunch of ideas to change it, stock options being the big one. So that's the background on this notion of agency problems. And then the question is, are the AG's role in tobacco, opioid, and so forth litigation, are the AGs properly, and the lawyers who represent the AGs, to the extent they're represented by private attorneys, as they typically or frequently are they representing their principal? The question is, what is the principal, as in the analogy to the shareholders? And then you have to ask, what are the typical AG roles? What initially comes to mind to most people on what an AG does is to enforce the state law. It's a law enforcement role. There's some of that involved here. There was some of that involved in the tobacco litigation under state consumer protection laws, but it was not the main thrust of the complaints, or how the attorney generals, I think, themselves conceptualized the cases. Maybe it was part of it. So that's part of it, is the law enforcement. The major part of it, at least initially, was financial. And for the reasons you said, that tort law, even normally operating normally, in cases you wouldn't think of as particularly public oriented, is nonetheless a public policy vehicle, because the deterrent effect of having an effective remedy is really carries out the public purpose of the tort doctrine involved. And that, I think, was what people at the time, at least the beginning of the tobacco litigation, thought was going to go on with the cases. And a major role of the AGs, and the most relevant one they thought, I think, was to get money back for the state. The state had expended lots of money on caring for people with tobacco-related diseases, just as in the opioid litigation, there's all kinds of expenses at the state and local level occasioned by the opioid epidemic. And they want the money back. And that's a very traditional role of AGs, a non-controversial role. If they don't do it, nobody else is going to do it, on their behalf. And the lawyers working for them, to the extent they're getting them money, are really, not, out of bounds, not off on their own trip and frolic, taking advantage of a leverage they have. They're really doing what the AGs want, and I'll get back to that in a minute. But the idea that the AGs also represent, the public interest generally and the public health in particular, I think is probably the third thought, in order of priority of what, AGs, should be doing, what their role is. And I think until the tobacco litigation, many of them didn't particularly feature that role. It was something that actually brought AGs very much into the public consciousness as a, carrying out this role. But I think for a lot of the AGs, a lot of their offices, this was new. On the issue of the agents, whether there's an agency problem or what the agency problem is with respect to public health, we had a very interesting, something that was important in my mind, at least, was at a conference we had, a predecessor of this, I think one or two conferences ago. This was a real life conference, and this was on diseases of despair. And we had an AG from one of the Indian nations who was talking very eloquently about the harm that opioids had caused to the people, and was totally persuasive, and this is terrible, something needed to be done about it. And so I asked the question, I said, how are you going to guarantee that the money gets spent on dealing with this problem rather than just going into the general revenue? And he responded, which in the bottom line is what the AGs did in the tobacco litigation. He responded, well, basically that's above my rank and pay grade, that this is going to be up for the council, whatever the governing council is of the Indian nation. And that's exactly what happened with the AGs, which is they announced when they settled the cases, they talked about this great public health victory, but the money, it wasn't exactly what happened. Some money did get used, and this was partly because I think they were in some sense, shamed into, or at least their counsel was, private counsel was shamed into doing this, but they, they did set up the Truth Foundation, the Legacy Foundation. They did run counter advertising. They did include very important provisions to end tobacco, most tobacco advertising, and end the tobacco industry's disinformation campaign. But as to the money, the overwhelming majority of the money, it went to the states that used it to patch roads and do tax refunds. I see I am out of my time. I'm supposed to stop, so I am going to stop. But again, great paper. Thank you.
Thank you. Thank you very much, Professor Day.
Thank you to you both. That was great. And congrats, Dan. That's wonderful. Next up, we have paper 4, Preemption and Privatization in the Opioid Litigation. Author Lance Gable from Wayne State University Law School, with commentary provided by Mark Gottlieb from the Public Health Advocacy Institute.
All right. Hi, everyone. Can you all hear me?
Yes, we can.
Excellent. Okay. Well, coming to you from outer space here. Happy to be a part of this. I want to thank Jennifer and Wendy and everyone at Northeastern for putting this together. It's been a really great conference so far. You know, some fantastic papers, and I feel like you know, my contribution to this fits really well with some of what we've already heard from Jen and Dan and Michael as well. But mine also focuses on the opioid litigation, and I'm going to talk in a little bit more detail about some of the issues that that have already been raised in some of the previous talks about the dynamics playing out, especially with the MDL, the multi-district litigation with the opioid cases. I originally had prepared some slides, but I think given the discussion already, I think I'm going to skip over the slides and just talk about the paper and highlight some of the major themes, which I think you've already heard something about already today. And you know, my paper really focuses on the one of the unusual dynamics that's been created by this litigation in the fact, and it kind of goes off of what Dick was just referencing in terms of the role of the attorneys general at the state level versus the role of the lawsuits being brought at the local level, which may comprise the majority of the cases that have been aggregated in the multi-district litigation in front of Judge Polster. This creates a really unusual dynamic from the perspective of the tension between those different litigants. And so what we've seen so far, especially as the multi-district litigation has gotten more and more large in terms of the number of plaintiffs participating with this creation of a negotiation class that would potentially encompass all local jurisdictions in the entire country who might potentially have claims related to opioid litigation. One of the things that we've seen is that there is this overt tension between what's going on between the different sets of plaintiffs. On the one hand, being the state plaintiffs represented by attorneys general and filing their claims largely in state court, versus what's going on with the local government plaintiffs, largely aggregated in the multi-district litigation and largely also represented by private attorneys. And so in Dan's talk, he highlighted really quickly in one of his slides issues related to preemption and also issues related to the sort of role of private attorneys. And so my paper really focuses on those two issues in a little bit more depth. And so I basically make the following overall points. You know, with regard to preemption, you know, the fact that states have on several occasions now taken they've made explicit attempts to try to intervene in the process of what the local governments are trying to achieve through their lawsuits against the opioid manufacturers and distributors, either by directly intervening, trying to get the local governments to combine their efforts with the state, or just dismiss their cases and allow the state's attorneys general to go ahead on their behalf. So we've seen that dynamic, and this is very reminiscent of some of the other attempts of state governments to preempt local governments in other areas related to public health. And so there's a parallel there that is interesting to consider. And so I'm going to talk about that a little bit more in a minute. And then, you know, the second big area that I focus on in the paper is looking at the role of privatization, and particularly the struggle over the role that private attorneys are playing, particularly representing local governments, and whether obviously some of the debates about the incentives of, you know, private attorneys versus you know, presumably public-facing attorneys working in the state level at the Attorney General's offices come into play as well. And so that's basically the overall thesis of the paper, that we're seeing these themes of preemption and privatization playing out in the context of litigation, which is fairly unusual, since we ordinarily, when we're thinking about those topics in the public health context, we often think about them in terms of legislation, policymaking, and other kinds of regulatory interventions to try to preempt or push back against privatization. So for starters, I wanted to go back for a moment to talk a little bit about the aftermath of the master tobacco settlement, because I think one of the reasons that we're seeing so many claims right now by local governments that have been combined into the multi-district litigation is one of the legacies of that settlement agreement, because it was driven by states attorneys general, and there are lots of problems with how the money ended up getting allocated, as we've already heard, in terms of very little of it going to tobacco cessation or any kind of public health use. One of the other legacies of that settlement is that local governments who were also affected by tobacco use really didn't get access to any of those resources, and or I shouldn't say any, but very little of that ended up going down to the local government level. It was mostly used at the state level, either for other things, or to the extent that it was even used for public health, it was used for public health at the state level. In this circumstance, thinking about the impacts of the actions of all the defendants in the opioid litigation in terms of the aggressive marketing tactics, the expenditures that local governments have had to make to respond to the opioid crisis as it's ballooned over the years, and as there's been significant impacts to many local communities, those governments took the lesson. One of the lessons they took from the tobacco litigation and the settlement was that they couldn't rely on the state's attorneys general to share any sort of resources that might be gained from a settlement with regard to the opioid manufacturers or distributors. And so that prompted a lot of these initial state lawsuits. And then that trend was exacerbated even more because of the structure by which these suits had been brought. So what I mean by that is, because the local governments tend to not have the capacity in-house to bring a complex lawsuit like this and to deal with this sort of very demanding, time-consuming suit within the limited budgets and limited resources that local governments have. They may not even have a council that's dedicated to public health at all in many or most of these jurisdictions. So while at the state level, the attorneys general and their staffs can handle this kind of complex litigation, the local governments on their own certainly could not. In come private attorneys who have the capacity and, in many cases, the expertise to bring this kind of complex litigation. And so what you see is local governments, most of those suits, most of the lawsuits that are compiled in the NBL are being done through the representation of private attorneys, many of them representing multiple jurisdictions. And there's an efficiency to this. There's very logical. There are many logical reasons behind this, including the fact that the private attorneys are taking these cases on contingency, and so the local governments don't have to put out the resources ahead of time. And if there is a settlement, or even if there's a judgment at some point in some of these specific cases, there may be the local governments will get some of those resources, and of course they'll have to pay some of the award to the attorneys as well for contingency fees. But that's a great deal for those local governments. They get the expertise, they get representation, and from sophisticated attorneys, and they're not having to put in any resources. And so that's driving the large number of suits as well. So now, because I know my time is limited, I wanted to focus just on a couple of specific analogies here that I try to make in the paper. When I talk about the issue of preemption, I try to make the comparison between some of the legislative type approaches to preemption that we've seen in many examples related to public health in recent years, including attempts by state governments to preempt local regulations on menu labeling, banning trans fats, environmental issues like anti-fracking provisions at the local level. We've also seen states preempt local rules and ordinances related to civil rights protections for LGBTQ individuals. We've seen a whole bunch of initiatives. Largely, the dynamic tends to be state governments with more conservative legislators trying to override public health related policies or civil rights related policies driven by more progressive officials at the local level, although that's not always the case, although that's most of the public health related examples tend to fit that model. And even recently with the COVID-19 outbreak, we've seen a number of examples of this. And actually, with regard to COVID-19, it kind of goes both ways in terms of legislative attempts or even executive order based attempts at preemption, where we've seen in Mississippi early on a few weeks ago, the state governor overrode local ordinances that had issued stay-at-home orders for their local jurisdictions. And essentially defined essential businesses to include almost any kind of business that was operating in the state. We've also seen, in many other states, state governments preclude local jurisdictions from making exceptions to stay-at-home orders. And so this is something that we've seen quite a lot happening, and there's a literature on this. What's the comparison I make in the paper is to say that what we're seeing with some of the explicit attempts by states to intervene in local lawsuits is a version of preemption, but it's sort of a litigation version of preemption that heretofore has been kind of unusual. And so there are a couple of examples. The states of Tennessee and Arkansas about 2 years ago explicitly attempted to try to intervene in some of their local level lawsuits against opioid manufacturers, and to essentially absorb those lawsuits into their existing state actions. These attempts did not come to fruition. More recently, though, especially as I said, as the MDL litigation has proceeded, what we've seen is as Judge Polster attempted to create the negotiating class, a group of state attorneys general filed motions to essentially prevent the negotiation class from being formed, and made a whole long list of arguments explaining why the state's attorneys general were the correct plaintiffs to be representing the interests of the state, that the local litigants really could not do that adequately and therefore should not be brought in to these settlement negotiations. And that debate over state versus local, and the explicit attempt, which eventually was actually rejected by the court to reject these local claims, raises some really interesting implications for preemption moving into the litigation realm. And so I only have 3 minutes left, so I want to turn in my remaining time to talk about the privatization aspect of my paper. So I also go into, in that section, discussion of how debates over privatization of public services had developed over the years. Again, normally the discussion centers on the advantages and disadvantages and legal implications, practical policy implications of outsourcing government functions, concerns about the fact that the more government functions are privatized, the less they're accountable to the public, and some other related concerns such as that. But then I turn to the debate over use of private attorneys to represent the public in the context of the opioid litigation, and also in public-facing litigation more generally. Because of shortness of time, I'm not going to get into too many of those arguments, but I want to kind of wrap up by focusing on the fact that these parallels in the privatization context are very different as well, because ordinarily the debates about the appropriateness or wisdom of privatization focus on the capacity of the state, and there are in many cases good reasons to pursue to bring in private entities to supplement state capacity. And here I think that would be the case as well. I think that the private attorneys really provide opportunities for the local governments here that would otherwise be available. On the flip side, there is also concern about the amount of resources that might be siphoned off to compensate attorneys taking these cases on contingency basis, whether that undermines some of the effect of the compensatory results that might come out of a settlement that could go towards public health. So I'll just wrap up by saying, there are many other inherent limitations to litigation here that I don't think get enough attention in the public discourse here. The fact that we're trying to use litigation to pursue a subset of defendants who initially caused a great deal of harm related to the opioid crisis doesn't address many of the ongoing and more pressing immediate issues that are going on as the crisis has evolved and moved toward a crisis driven a lot more by illicit use than by prescription use. And that's an issue that highlights the fact that litigation, because it's such a retrospective and belated type of intervention, really has significant limitations in being able to shift effects on public health. So I'm going to stop there because I'm out of time, but I'll turn over to Mark and hear his comments and thoughts.
Wow, that was great. Thank you for that very thoughtful presentation, Professor Gable. You know, you've identified a veritable smorgasbord of reasons why this constellation of opioid lawsuits presents a potentially impossible situation to resolve. And I'll just take an opportunity to provide my take on some of these issues and consider what, if any, path forward may that could benefit the public health may yet exist. As you pointed out, much of this approach is built around the template of the litigation that led up to the MSA, and that may not end up being the best template in this context. Back in I guess 1994, when Mississippi filed the first case against the cigarette companies, there were a number of localities that filed their own cases before the states acted. Hang on a second, I just got a chat notice here. Anything exciting? Oh, fantastic work, Lance. So, there were local cases that had been filed by San Francisco County, by Los Angeles County, and New York City, as examples. And those claims, like those brought in the MDL in Ohio, sought to recover the costs to those localities caused by the acts of the defendants. Ultimately, however, the MSA was signed and each state released its claims against the defendants, as well as those of any political subdivisions of that state. So these included also claims of county hospitals that are similar to some of those that are included in the MDL in Ohio and the opioid MDL. So but this is a totally different situation, really. The acute nature of the opioid crisis really stands in contrast to the more chronic nature of the sort of the long-standing public health crisis that was created by the tobacco industry. Even though, the morbidity and mortality caused by the tobacco industry may, greatly exceed that caused by opioid pain manufacturers and even the illicit products and illicit use that has caused so many problems. But this was really acute, so as the evidence of the wrongdoing by many defendants, especially Purdue Pharma, began to emerge, which does sort of hark back to all of the internal documents and stuff that were leaked around the time of the state cases against the tobacco industry. But the evidence, along with these record rates of overdose and mortality that we had seen in the last several years, created a litigation feeding frenzy that was, believe it or not, it's even more intense than that we saw in the 1990s against the cigarette companies. And I think, as you've pointed out, it's really left us with an unimaginable national docket, including the MDL and all of the dozens of state cases. And this is not going to be easily resolved, and there is no elegant solution to this. And the feeding frenzy, as you pointed out, has been driven largely, or at least substantially, by the private plaintiffs' bar, in so much as in most cases they're indispensable for the claims to be filed and for them to move forward at all. Local plaintiffs, lack the litigation expertise and the financial resources to advance these cases for the most part. And we have something like over 3,000 of them that are now filed in the MDL in Ohio. And there's just the municipal attorneys aren't prepared to take those on. It wouldn't happen. This extends to many AG's offices as well. And it's not entirely a bad thing. And without them, there would be substantially less pressure on the defendants to either settle or to fundamentally change practices that led to the crisis in the first place. So I think that that element of privatization is really essential here. In the case of the master settlement agreement in the 1998, the attorneys weren't actually compensated by contingency fees, because the contingency fees create a real problem. It's politically damaging to their clients, right? If you're a municipality or a state that has lost X hundred million or $1 billion, and you're trying to recover that, but you're going to give 20% of it or 25% of it to these private attorneys, that really is sort of untenable politically. So, in the case of the MSA, a separate arbitration process that was not funded by MSA money ultimately compensated the private firms. This might be a workable model in any MDL litigation master settlement, should we ever get to that point. But, when it comes to finding a settlement that benefits public health, one must be wary of the private players setting the terms or even framing the discussions, because, fundamentally their approach to this phase of the advocacy may not result in the best public health outcomes. That said, I think that, the plaintiffs' law firms that have been leading the charge in the MDL, and this, this settlement proposal that was led by, fashioned by Joe Rice of Motley Rice, may actually be the only workable solution based on sort of the number of claims, the variety of claims and defendants. It's treating this as a settlement class, essentially. Consisting of all the local plaintiffs that are in the MDL and allowing other local plaintiffs who have yet to file to opt in may be the only way forward, because there's far too many cases to even begin to really meaningfully try. And, as you pointed out, there are insufficient resources out there even to make the defendants whole. So a settlement in the manner of a class action would seem to be the only workable solution. But is it even? What about all of these state cases that are not in the MDL? They're arguably some of the most powerful cases out there. If they seek a separate MSA style settlement, is that even something that can work in conjunction with an MDL class action style settlement as proposed by the plaintiffs in the MDL? And the court is attempting to move forward with, or could they actually join in? Could it become one big settlement? Is there any way forward? It's really hard to tell. One place that I've seen where the chaos of many of these issues raised is evident right now, and is concerning, is in the federal bankruptcy court in White Plains, New York. And that's where Purdue Pharma has filed for Chapter 11 bankruptcy protection to relieve the settlement pressure that's been placed on the company and its owners, the Sackler family. by the MDL as well as by the many state cases. So the list of creditors, as you can imagine, is rather daunting, and it seems so far, at least in its early stages, it appears to be sort of a vicious battle among these creditors seeking to get a piece of whatever is left of Purdue Pharma, and to get as much of the Sackler fortune as possible, because there aren't sufficient resources out there based on the the extreme nature of and the extent of these financial injuries. So the plaintiffs are all battling for a plan that'll put them in the best position against maybe the most culpable of the defendants. So it's further complicated the prospects of any kind of settlement, and stayed the proceedings against Purdue in these actions. As Professor Dana described, the amicus brief filed in the MDL seeking public health relief that Professor Parmet and I filed last year. We wanted to have a public health voice as part of these settlement negotiations, and wanted the court to really consider the public health really as a party to this, even though we're not a plaintiff. The public health community is not a plaintiff. So we sought a coordinated national NGO response to the opioid crisis that would be funded by a portion of the settlement funds. And we argued that while local plaintiffs deserve to be compensated, it's of utmost importance, if we're to meaningfully address this crisis, for there to be a centralized, coordinated approach as well. But the public health outcomes is not really a creditor that has any voice in a bankruptcy proceeding. And Purdue has made the resolution of these cases considerably more complicated and difficult through its Chapter 11 filing, as well as a resolution, the feasibility of a resolution that could benefit public health. And I wonder if, just to make things more messy here, if other defendants might not try the same approach. So what's the way forward here, right? On the litigation front, it seems that a compromise, global settlement of some sort would make the most sense. A settlement that covered all plaintiffs and acknowledged that there aren't sufficient current or even future assets to fully compensate the plaintiffs here, and that the industry, right, the opioid pain medication industry can't be wiped out, because they make medication that is a medical necessity for many people. So some sort of balance and a compromised global settlement would have to be struck in order for this to proceed, and that's going to be very difficult to do. But importantly, a coordinated public health response has to result from any sort of settlement like that, or else the crisis will just continue, and it won't abate nearly as quickly as it needs to. But you know what? This might not be even a possible outcome. And I hate to say it, but maybe the only way forward would be a comprehensive global settlement that is a legislative solution. It may be the only remaining way to resolve these cases in a way that would be fair to the plaintiffs and result in some positive public health outcomes. So obviously, that seems rather unlikely currently. The viability of something like that in the current political environment, it seems far-fetched. In the case of tobacco, this was actually attempted, and Senator McCain filed a bill that sought to settle the cases as well as enact various tobacco control public health pieces as well. Ultimately, it didn't go forward. It was a big deal at the time, and at a time when bipartisan work on public health issues seemed more likely than it does today. But it may be really the only way to resolve the mess that you so aptly described, Professor Gable. It's pretty ugly. But thank you so much for laying it out so clearly.
Thank you for those very insightful comments.
Sure.
Thank you. All right, next up, we have paper 5, the fourth wave, public health litigation, e-cigarettes, and the cigarette endgame. Micah Berman from The Ohio State University will be presenting his research and his paper, and Monica Valdez-Lupi from the de Beaumont Foundation will be providing the commentary.
All right. Hello, everyone. Welcome to the reading nook in my bedroom. I've got a 5-year-old sitting nearby in the room with me, so hopefully he will let me get through this. But you know, I obviously wish we could be together in person, but I'm so glad to be part of this event, and thanks to Jennifer and everyone who helped put it together. I really wanted to be a part of this event to be able to pay tribute to Professor Dick Daynard, whose work has been such an important inspiration to me. So, you know, I've spent a lot of time reading his work, and I'm going to pull up my PowerPoint here while I'm talking. You know, when you sort of work backwards from all the things that he has written, it seems that there are 2 questions that have been really central to a lot of his work. One is, you know, what is the next wave of litigation against the tobacco industry? We'll talk about waves again in a second. And then second, you know, if we're going to have more ongoing litigation against the tobacco industry, what is the public health goal here? How does that work towards eliminating or at least minimizing tobacco-related death and disease, as you know, and many of you today have been talking about that sort of same topic. How do we get towards the public health goals? So I'm loath to step in on Professor Daynard's area of expertise here, which is not as much my area of expertise. But my idea with this paper was to kind of tentatively rethink these 2 questions in light of where tobacco control is, where the tobacco industry is today. So, you know, just to back up, Professor Daynard has long argued, as he did in this article back in 1997, that I'm just going to read it here: tobacco products liability litigation is one of the most potentially effective means of controlling the sale of and use of tobacco. And this article here refers to these various waves of tobacco litigation, and this particular paper was arguing that the first 2 waves, which went up to the 1990s, were essentially unsuccessful, at least from the plaintiff's perspectives. But the third wave, which was going on when this article was written in the late 90s, you know, had much better prospects. As you all know and has been discussed, plaintiffs did break through in that third wave and start winning cases, and there were you know, important settlements, including the master settlement agreement. But I think it's fair to say that litigation did not turn out to be the complete game changer that it was hoped that it might be. Since that time, you know, Professor Daynard and Mark Gottlieb and the rest of the team there at Northeastern, you know, have done terrific work, you know, being on the lookout and thinking about ways to push forward and think about what the next theories are, what the next potential wave of litigation might be. I'm going to circle back to litigation in a minute, but I wanted to switch gears here and say that, you know, while continuing to push on litigation, Professor Daynard also has shaken things up on the advocacy side as well. He wrote in 2009 this provocative piece suggesting that, in addition to litigation, we should also be, thinking about taking a more direct approach and just banning cigarettes. And the proposal here was not to ban tobacco sales entirely, but to ban cigarettes in particular. And he wrote, quote, "Cigarettes are the dirty needle of nicotine delivery devices. Phase out the cigarettes while permitting non-smoked nicotine delivery devices to remain on the market, and the great majority of tobacco-caused diseases and deaths will disappear." And that goal of phasing out the sale of cigarettes entirely, sometimes referred to as the end game idea, that was seen as fairly radical at the time, a little more than 10 years ago, but I think is now much more widely accepted among tobacco policy advocates, if not the general public. And Professor Daynard has played a very important role in making that shift happen. As it turns out, he wasn't just convincing for other tobacco control advocates, but the major tobacco companies now seem to also agree with him. This is the website of Philip Morris International, the largest transnational tobacco company. Their real official corporate tagline is delivering a smoke-free future. And they're an international company, but the main U.S. companies are now all saying some version of the same thing. That in the long run they would like to get out of the business of selling cigarettes and only be selling less harmful products. Obviously, or I think it's obvious, they don't mean it. It's a great PR approach, and I think they are certainly preparing for a world after cigarettes, but they're certainly not rushing towards it, and they are not going to get there without getting pushed and forced into it. But the reason they are talking this way is that they are now in the business of selling e-cigarettes, or at least something like e-cigarettes. And so claiming that their ultimate goal is a smoke-free future helps to buy those companies regulatory cover to push their e-cigarette products, in some ways to renormalize their corporate image, while at the same time they are not at all letting up on their aggressive promotion of cigarettes. These same companies, they're a bit careful in how they do it, but they are all now on record stating over and over again that, including in court cases, that e-cigarettes are less harmful than cigarettes. This is from the R.J. Reynolds website, where they say that this is in graphic form, the same thing on Altria's website, the parent company of Philip Morris, making this argument, saying that the products other products they have are less harmful than cigarettes. They also say that their e-cigarette products are terrific substitutes for cigarettes. If you are smoking cigarettes, you should be able to make the switch and smoke these products instead. So the question that's been on my mind is, if we now have the tobacco industry saying that these products are less harmful than cigarettes and great substitutes for cigarettes, why are they still permitted to sell cigarettes? It's obvious why they are still selling cigarettes, but why are they still permitted to? And so, circling back to litigation as a tobacco control strategy, I'm going to oversimplify dramatically here, but usually, if someone is selling a dangerous and deadly product and there is a safer alternative available, that is grounds for liability in court. In the past, tobacco litigation has been hindered by the absence of a feasible alternative design or reasonable alternative design. It's called different things in different jurisdictions. But the defense argument by the cigarette companies is that yes, cigarettes may be deadly, something they now admit, but that's just the way they are, and there's no way to make them less dangerous. So there's no viable alternative that can be pointed to, and so they have no liability. But now, as I said, you have the companies themselves arguing that there is an alternative it is less harmful, it is acceptable to consumers. So, is there a litigation strategy here that could use the industry's own words against it? And I just wanted to be clear that I'm talking about litigation directed towards cigarettes. As there is a lot of litigation going on about e-cigarettes, which is a separate topic that we could have a whole other discussion on. But here I'm focusing on cigarettes, which, despite still declining use, are still the leading cause of preventable death in this country, and a major public health problem. So I think if that's the litigation theory, there are challenges. One that I will get back to is the question of whether e-cigarettes really are an alternative design of a cigarette, or whether instead they're just an entirely different product. So they're not, it's not a version of a safer cigarette, it's just something else entirely. The tobacco industry has argued that, this is like comparing wine and grape juice. Grape juice is safer than wine, but it's a completely different product. It's not an alternative design of wine. So we'll come back to that challenge. The second challenge is that if you are talking about at least individual litigation, there would have had to be a reasonable alternative design available to the company at the time the plaintiff started smoking, or at least at the time the plaintiff started using that company's product. And that second point might seem to be a dead end, but in fact it's not. There has been some important but under-publicized research examining industry documents showing that the industry was exploring the possibility of e-cigarettes all the way back in the 1960s, and they did not move forward with actually commercializing them, at least in part because they viewed them as potentially viable alternatives or substitutes for cigarettes, and they didn't want to compete with their own bestseller. So I'll go through that in my paper in more detail, but here's one example. This is BAT, British American Tobacco's product Ariel, a patent that was filed on its behalf. They actually hid the fact that this was BAT's patent by having Battelle sell it, which is having Battelle file it, which is just a couple of blocks away from my house where I'm sitting right now. But their internal documents show the project leader saying in the 1960s that creating what is essentially an e-cigarette was, quote, feasible and achievable. So I think just think about that. The industry had the ability to create a less harmful product in the 1960s, and chose not to. Instead, they promoted products like light cigarettes, which pretended to be less harmful, but in fact weren't. And there are perhaps millions and millions and millions of lives that could have been saved if they had acted differently. I'll just go through these quickly. Later in time, this is Philip Morris's version of it, the capillary aerosol generator. Again, pretty much an e-cigarette. Again, the obstacle wasn't that they couldn't bring a product like this to market, but that they didn't want to. And of course, we know that's exactly what ended up happening. It was independent companies that actually did bring e-cigarettes to market and got them to take off, and only then did the big tobacco companies move in to get a share of the market, sometimes with their own products and sometimes by buying up others. Finally, R.J. Reynolds did similar work in the 1970s, notably developing but never actually using nicotine salts that are the innovation that drove the popularity of Juul. And the founders of Juul, as you can see from this picture, were well aware of that work and used it to inform their work. This is James Monte, is one of the founders of Juul, talking about it in his seminar presentation at Stanford Business School before they even launched the business. So, depending on what you're talking about, it may be possible, depending on what date you're talking about, it may be possible to show that some version of an e-cigarette was a safer alternative design that tobacco companies could have pursued but chose not to. Some of this research that I've just mentioned is new, some of it is older, some of it has been attempted in court before. But I do think that the actual commercial success of e-cigarettes over the past several years, the last decade or so, puts it in a different light and makes this alternative design argument more compelling than it was in the past. So I think this type of litigation has some appealing pros, one of which is that, at least potentially, it cuts through the harm reduction debate. There's a very intense debate now about whether e-cigarettes are a good thing or a bad thing for public health. Now, I think most people on both sides of that debate would agree that, in a world in which e-cigarettes were available for sale and cigarettes were not, there would be, the public health benefits would be immense. Can fight about how immense, but that would be a better situation for public health. People like myself who think that e-cigarettes are causing more harm than good in the present circumstances, could get on board with that. I think e-cigarettes are particularly harmful because they can lead to cigarette use. But obviously, if we're talking about a different world, then that's a different issue. Second, even though, as a literal matter, you might not be able to use the tobacco industry's present day words against it, the public commentary on such litigation could and presumably would point out the cynicism and hypocrisy of the tobacco industry's argument. There's lots of challenges too. The historical record is murky. There were also technical challenges that the industry did face. So figuring out their exact motive for dropping these products is a little complicated. The industry has in some cases brought other alternative products, not e-cigarettes, but other alternative products to market that were flops. So the historical issues are still complicated and difficult, and there's room for more research there. And then, secondly, the question that I mentioned before, is this an alternative design or is this a different product altogether? And that's, more than I'll get into here, but I just wanted to note that, again, you have the industry's own words to use against it. You can get into the metaphysics, but the question here really is, what is a cigarette? And the industry has long recognized that a cigarette is a delivery device for nicotine. That's why consumers use it. And so arguably this is not, wine versus grape juice. The product is a nicotine delivery system. And, the industry has long chosen deliberately to sell the most harmful version of that product, and has continued doing so even when other alternatives are available. So I'm seeing that I'm out of time. So just to wrap up real quickly, I don't want to understate the challenges here, but I do share Professor Daynard's conviction that it is long past time to demand that the industry live up to its cynical new rhetoric and stop selling cigarettes, which, as he said, would save millions and millions of lives. And as Professor Daynard and also Professor Parmet have written, that litigation doesn't have to be successful to have a positive impact. It could help to reframe the public understanding of cigarettes, put pressure on the industry to respond, perhaps catalyze grassroots efforts to push forward and demand change at the local level, and again, a whole other talk, but you are starting to see that happen in really exciting, creative ways. So I think there's an opportunity here for a synergistic relationship here between litigation and advocacy. So, finally, just to close, my son Seth is right here with me. I'm gonna lift him up. This is Seth. He made this card yesterday for my former colleague, Dr. Amy Acton, who is now the director of the Ohio Department of Health, to tell her what a wonderful job she is doing. Public health, as you all know, tends to only get noticed in moments of crisis. So, people are paying attention to it right now, but I just wanted to mention I'm so, proud to be part of this community with all of you. And I just thank you for all the tremendous work that you all are doing day after day and year after year. Thank you. If I can, there we go.
What are you doing?
Good afternoon, and thank you, Professor Berman, for running through those slides as I try to cue this up. Let's see if this works. Do you see that okay, Jennifer?
Yes, I do. If you just
Okay.
want to.
Thank you. Good. Okay. And I want to thank, again, Professor Berman for running through those slides, and also a thank you to Jennifer and Wendy for inviting me to join you all this afternoon. Again, my name is Monica Valdez-Lupi, and I'm here as part of my work with the de Beaumont Foundation as a senior fellow there. The de Beaumont Foundation is based in Bethesda, Maryland, but my work and I guess my perspectives and thoughts about your paper and your slides, Professor Berman, come from a place where I have experience, most recently leading the Boston Public Health Commission, which is the local health department for the city of Boston, and had the honor of working with Donna Levin when I was at the Massachusetts Department of Public Health. And I wanted to also start by saying that this was a welcome break from a lot of the things that I've been reviewing and working on as it relates to COVID-19. So thank you. As I was thinking about the slides that you just presented, and when I was reviewing it the other day, I was thinking about our own work in Boston, which isn't unique in terms of what we see happening across the country. And up until just recently, a couple of years ago, we were very excited in Boston to see that we were on a downward trend in terms of youth tobacco smoking. And our wonderful team in our General Counsel's office helped us prepare this slide for our board as we were reviewing our tobacco control regulations last fall, just to show them the dramatic decreases that we were seeing. And we could directly tie this back to regulatory work that started way before I rejoined the health department. So really back in 2003. So between, this 14-year span, really beginning to see the benefits of all of this work that had been put into place by the Board of Health. But I think you talked about this, Professor Berman, in terms of marketing and targeting different populations. And definitely big tobacco has been very successful in what I would describe as weaponizing e-cigarettes and creating this next generation of smokers. We know from the Surgeon General Jerome Adams' report, that 20% of our youth or teens, or about 1 in 5, are using e-cigarettes, and 2% of adults are also using e-cigarettes. And what I know from the work we did in Boston and from work that's going on nationally is that the bottom line is people are not only vaping, but also smoking cigarettes. And what worries me the most is that you talked about alternative product design, but I'm also concerned and wondered if you had thought about the e-cigarette and the fact that Juul pods in some data have shown that it's equivalent to basically 20 cigarettes. And we also know that for youth that are smoking or using e-cigarettes, that about 30% of them go on to smoking traditional or combustible cigarettes in 6 months. So this is actually a concern. And I wondered if you had considered that, because it's hard for me as a public health practitioner and someone who's both worked at a city level and at the state level, so regulatory work happening at both city and state public health departments. It's challenging to separate the two. And so I wonder if you go into that in your paper. I actually had a question for you, but you shared another example about Manhattan Beach. So, you know, in much of the work that we see coming from at the municipal or the city level, a lot of the work often happens on the West Coast or the Northeast. And so that was a question that I had for you after Beverly Hills. Were there other communities that were taking such proactive steps as banning cigarettes altogether? And when I think about work in Boston and other big cities, I know that Boston isn't Beverly Hills and Boston isn't Manhattan Beach, and where racial and ethnic health disparities come into play in the work that you described in terms of banning cigarettes. We know that there's been longstanding history over decades of big tobacco that's distributing and marketing all tobacco products to our Black and Brown communities. We heard this when we convened community partners last summer to ramp up and to get our communities behind changes with our latest ban. It was in November, the Board of Health passed rules to ban menthols, and that built on Tobacco 21 and flavored bans in the city of Boston. And they described cigarettes being sold individually in neighborhoods like Dorchester and Roxbury when they were children. And so that is something I know that big cities and larger jurisdictions around the country are really paying close attention to. And that leads me to my next question. And I would love to see how this is developed in the paper that you're working on, this all or nothing or this endgame approach, because we do hear from big tobacco this argument about e-cigarettes being useful in terms of harm reduction. And I would say that when you talk to public health practitioners and different public health professionals, I think there are arguments on either side to be made in terms of e-cigarettes being used as a method of harm reduction. And so I would be interested in seeing how that shapes up in the paper. And then finally, while I was thinking about your slides as being a nice welcome break from COVID-19, none of us, I think, in the work that we do can escape the fact that everything from all the different places and roles that we play in the worlds where we work, we can't escape looking at the world differently and through the lens of COVID-19. And so I wondered if there might be an opportunity to use this global pandemic to accelerate some of the work that you described in terms of litigation efforts, and was especially disturbed, but also understand why the FDA has requested, I think I read this recently, delay, an extension in for e-cigarette manufacturers to apply for demonstrating the public health benefit of their, in order to keep their markets on the product, pushing this back now to September. And it just seems like, I understand that the plaintiffs are not going to oppose this request, but I'm a cynic and I almost see this as another delay tactic. So I wonder, you know, especially when you see some of what the FDA is saying, that because of the damage that e-cigarettes and tobacco cause on lungs, that puts people who smoke or vape at a disproportionate risk of complications from COVID-19, whether there might be a window of opportunity in terms of the work that you're proposing in your paper. So I want to thank you again for allowing me to listen and to learn and provide some perspectives from sort of what I've been looking at with our public health departments. Thank you.
Thanks. Yeah, I know we got to move on. I don't want to take up much more time, but I really appreciate those comments. And I do think, I don't want to minimize the harms of e-cigarettes, and I didn't mean to. But I do think that, in thinking about the challenges of e-cigarettes, if we sort of leave the issue of cigarettes behind, that's where we are ignoring the massive racial ethic disparities that have now developed on the cigarette side. I think it's really important not to do that as well. But I appreciate the comment. I'll make sure I integrate that in the paper.
That's great. Thank you so much to you both. All right, paper 6. We're about to start. The procurement of public health litigation and its implications for public health, featuring 2 co-authors. We've got Ruben Gutmann from Gutmann, Bushner and Brooks, PLLC, and Liza Vertinsky from Emory University School of Law, with commentary by Eric Gold from the Mass AGO office. So give me one moment. There we go.
Great. All right, I guess I'll go ahead and get started. And this is joint work with Ruben, and I'm going to turn it over to him for the second part of the presentation. I'm just going to sort of share my screen. 1 second. Here we go. So first, I want to start by joining the chorus of thanks to Jennifer and to Wendy for making this conference happen, and also to Eric for making the time to talk with us about our project earlier and then for his comments today. And our project focuses on kind of the process, what the litigation process looks like. So it's maybe focusing a little bit on kind of the practical decisions along the pathway in the litigation process, and how those might be influenced in contexts where attorney generals are working with private law firms. And so it really dovetails on a lot of some of the things that have been talked about in the earlier presentations. And when we talk about partnerships, we're really talking about both direct procurement of private counsel, right? So you contract out to private counsel, and that brings with it issues where there are contingency fee arrangements, but also interventions in qui tam cases. And we recognize that there are important differences between those, but also we argue there's some shared problems between them. We focus primarily on state attorney general litigation, but again, the issues and the opportunities generalize both upwards to federal and sort of then also to municipal private law partnerships. And indeed, there's perhaps an increasing number of the private law firm municipal partnerships to think about. In the existing literature, some great work by Jennifer, by Lance, and others, including Margaret Lemus, have explored in detail some of the challenges that arise in what we can call maybe the privatization of public health litigation. And there's been a lot of discussion and public debate about procurement practices in particular, and the particularly focusing on contingency fee arrangements. In our project, we kind of take as given, so this is sort of not a normative project, we take as given that these relationships will continue. And what we really want to do is focus on how the mix of incentives that come into play, both on the side of the private law firm participants and their attorney general counterparts, can influence a variety of decisions that are taken along the litigation pathway, such as case selection, the nature of discovery, confidentiality agreements during the process, admissions about conduct, and in particular, thinking about impact on the nature and the structure of the remedies. And this ties in with some comments made earlier about the problem with the retrospective nature of litigation. That doesn't have to be the case if your remedies are focusing on structural change. So that's one thing that kind of motivated our interest in this project, is really thinking about how could we get structural change to occur to come out of these types of lawsuits. So our ultimate goal is to identify some practical guidelines or best practices for these public-private litigation processes that could emphasize or give greater emphasis to public health objectives. And that's something that Ruben will talk about a little bit later. So we began, as a lot of people have, with this idea of kind of the evolution of kind of a different role for the Attorney General arising out of the tobacco litigation. One of the things that we focus on in particular in looking at the evolution of the private law firm partnerships with Attorney Generals is this sort of notion of the legal research and development that goes into creating novel theories and then implementing novel theories. That can be a time-consuming, expensive process. And that's one of the things that private law firm models lend itself to. So a lot of the private attorneys who came into the tobacco litigation were seasoned attorneys who had tried out sort of similar theories in other contexts and had the capability, the expertise, the ability to invest in what we kind of call legal R&D to bring these cases. So the reasons why these partnerships arise have already been touched upon. There's some earlier discussion about some of the barriers that private plaintiffs have faced in bringing kind of public health litigation, including heightened pleading standards, including barriers to class actions. And there's also been discussion of the resource constraints that Attorney General's offices face. So even though they have grown in size over time, they're still constrained, and they don't have a tremendous control over their budget. So it's not a surprise that the private law firm Attorney General relationships have been increasing. And one of the things that we focus on is looking at kind of the strengths and the weaknesses that each party brings and figuring out how could we identify some guidelines or practices, best practices that could be adopted so that we can maximize or we can leverage the strengths, given that these relationships are already occurring, and perhaps safeguard against some of the problems that might arise. And we a lot of our time in this project, which is still sort of in early stages, has been trying to understand the mix of incentives of the different players involved. Some of those incentives are structural in the way that the system is set up. Some of them are endemic to the sort of the business model or the institutional models of the players. But we take that set of incentive structures and we try and identify how that public-private partnership, that meshing of incentives, may influence decisions along the process from identifying which cases to be should be brought all the way over to what types of damage models are being used and whether to settle and with what consequence. And so if we think about some of the challenges on the private law firm side, it's fairly obvious that a lot of the focus there is on looking for cases that utilize existing capabilities and in looking at where the damages are and how fast those damages can be obtained at what cost. The Attorney General's office have a variety of different incentives. Some are private, some are institutional, some are public interest goals, which creates sort of a mixed environment in which they've got political pressures, decisions on what to pursue or not to pursue, reputational interests, interest in sort of credit claiming for certain successes, certain monetary damages, impacts on budgets, limitations on budgets, and institutional constraints arising from the needs to satisfy multiple constituencies. So they've got a lot of different interests and stakeholders to juggle in determining which cases to pursue, and that may impact, again, some of the decisions they make along the pathway. The result, and this is drastically oversimplifying, but the result is that litigation decisions are sometimes driven with an eye on dollar damages and without full consideration right of the breadth and the scope of harm that's been done or the impact on the results of curbing wrongdoing, right? So not a whole lot of attention sometimes to what types of structural changes might be achieved. And also, as something Jennifer focused on from the beginning, the importance of having a strong public record in which there's admissions of misconduct and there's a lot of information about the types of behaviors that are at risk. I'm just going for a minute or two more, and then I'm going to turn it over to Ruben. So in looking at this mix of incentives, we then try to map out on the litigation pathway the choices that are made, the consequences of those mixed incentives on how the case unfolds, starting, as I said, right from the beginning in which cases get brought, how they get brought, which claims are focused on, and ending up in this issue of what's the outcome? Is there a settlement? Is it private? Is it public? Is the focus simply on damages and where do those numbers come from? Or is there real thought as to how this might then go back and influence things like procurement decisions going forward or influence structural changes so that that type of misconduct doesn't occur again? the hard part, of course, is to figure out what's needed, and that's what's needed in a pragmatic way, right? What kinds of practices might we what might we come up with? For example, maybe there are certain required provisions in the contracts you work with private firms, independent oversight. So the part that we're working on right now is what can we suggest as a practical matter that might guide these public-private partnerships in a way that keeps public health central to the conversation. And I'm going to turn it over now to Ruben to sort of think through and talk about some of the things that we would like to see or that we're going to suggest in terms of guidelines or best practices.
Well, first of all, thank you for allowing me to participate in this. As a practitioner, it's very, very helpful for me to be in touch with the academic world so I can understand where what I do fits into the greater scheme of things. To put things in context, 60 years ago, 1950s, 1960s, the model was that private attorneys were chasing government action. So if there was a government antitrust prosecution, then what would happen is there'd be private actions that would follow on that. And for those who have studied the MDL situation, like Professor Olivier, who talked earlier, the whole notion of an MDL came out of public government prosecutions of antitrust derelictions in the 1950s, which led to a myriad 3,000 antitrust cases being filed in the 1960s. And so that was the model, that you would look for government action and the private sector would follow on. Well, in 1965, when Ralph Nader published Unsafe at Any Speed, essentially what he taught us was that we could all be private investigators, private attorney generals, and we can do our own investigations. And that spurred what Lisa talks about as this sort of R&D in the private sector. And then so for a while, you essentially had two tracks. You had, the government prosecutors, and you had the private sector prosecutors. And then as the private sector prosecutors had an inability to bring the kinds of cases they wanted because of the crackdown on class action regulation or the pleading standards or restrictions or cutbacks in the ability to move a case past summary judgment, or the Daubert situation, and essentially coming down into the Iqbal where you need to plead plausibility in order to even get into court, there was a natural marriage of the private sector and the public sector in terms of bringing these cases. So we see problems in how these cases are being brought, problems in the sense that we think that we can do better than what we're doing. I've been involved in these cases personally, and one of the reasons that I like being in this dialogue is because I think that the impact that I've made through the litigation that I've done really hasn't even made a dent in the problem. And so we think that if you regulate the relationship or think harder about the relationship between the public and the private sector, which is this marriage, which has actually done some good, you can actually do even more good. So let me say a few things that sort of come to mind. One is that focusing on the pharmaceutical industry, if you look at most of the pharmaceutical manufacturers, a large majority of them are actually convicted criminals. And when we think about the opioid litigation, which we've been talked a lot about today, the truth of the matter is that the impact of the derelictions by the opioid manufacturers, including Purdue, have been staggering. But the reality is that the practices permeate the entire pharmaceutical industry. And in fact, in 2009, Purdue was prosecuted in the Western District of Virginia, and the government knew exactly what they were doing, but the government didn't take full recourse against Purdue. And we're 11 years later, we're doing something that we should have done 11 years ago. And in fact, we have litigated as a governmental entities against, Glaxo and AstraZeneca and Abbott over drugs like Seroquel, Risperdal, Depakote, right? And we've learned a lot about these practices, yet it seems to me that each one of these cases we bring seems to almost appear as if it's reinventing the wheel. So we really haven't not learned the lessons from the cases we've brought. And a lot of that has to do with the transparency problems that we've been talking about. That is to say, discovery has been conducted under cloak of confidentiality. And sometimes these cases settle before full litigation. Most of the times there's no trial. So there's really no public airing of any of this. So transparency is a paramount problem. So let's talk about the fixes that I would think about. One is that whether a case is generated organically by an attorney general or a municipality or a private sector entity, when a problem comes to the table, there needs to be an immediate impact statement in terms of, who are the constituency groups that are impacted? Is it Medicaid? Is it the public health and welfare plans? Is it citizens? Is it all three? And if in fact there's a wrongdoing that includes a violation of the law, in fact, is there an impact on, for example, a state pension plan to the extent that they've invested in a company that may be operating outside the scope of its corporate charter to the extent that it is engaged in an unlawful practice? So first, there's got to be that analysis. And the second part of it is we jump to the notion of litigation, but should we also be thinking about, do we immediately make changes in our procurement practices? That is to say that if we know that a company is paying kickbacks to induce prescriptions or it's off-label marketing a drug, why is it that we don't get together as an attorney general with the health and welfare funds and the pharmacy benefit managers and the intermediaries for the Medicaid system and put them on notice that this type of conduct is going on and they need to watch out for it? And why don't we then figure out whether, when they look at whether the use of the drug, for example, is supported in an off-label context, whether they're relying on entries in the compendia that have been induced by fraudulent conduct. And too often what happens, these cases drag on for 4 or 5 years, and the procurement goes on and we don't mitigate our damage. We don't mitigate our damages. But what's more important is, and we've learned this in the case of the atypical antipsychotics, which were prescribed to children, we cause harm to a community because, for example, kids who take these drugs may have a higher incidence of diabetes. So when we're confronted with these problems at the get-go, it seems to me that there should be an impact statement and the constituency groups need to be brought together. When I think about an impact statement, I draw an analogy to an environmental impact statement. And when you look at that framework, the goal of these relationships should not purely be measured in terms of a monetary recovery. It should be measured in terms of how we're going to affect the market going forward. Because what happens in most of these cases, almost all of these cases, is the pharmaceutical industry, at least, and I'm litigating it against Massachusetts General Hospital with regard to concurrent surgeries, you're talking about practices that impact the standard of care. Wrongful conduct has poisoned the standard of care. So you've got to reset the standard of care. You've got to engage in a re-education process. So I would make it paramount in the relationship with the private sector lawyers that when they go to court and they negotiate agreements to get documents, that those documents, to the extent possible, receive the broadest possible transparency. We see, for example, Rule 26 of the Federal Rules of Civil Procedure, what Professor Olivia alluded to, providing for confidentiality agreements. Well, what's new is that agreements are being negotiated where documents are produced in discovery that are not confidential, and they are only allowed to be used in the litigation. I'm going to sum up quickly. The idea of an environmental impact statement, an analog to the environmental impact statement, an impact statement about this litigation carrying through from the beginning to the end of the litigation, to documents that are produced in the litigation being put on the website of the Attorney General or given to universities. The idea of figuring out how to make litigation or bring it back to what it was during the era of Ralph Nader, which is transparency, so that the medical community can be enlightened. And at the end of the day, when you get money out of these cases, you take that money, you put it into continuing medical education, you take medical education out of the hands of the drug industry, and then you take some more of that money and you send it back to the attorney generals and you allow them to put it into enforcement compliance. And I think what we're talking about is a mechanism to better balance the relationship between the private and the public sector in litigating these cases, which is the relationship that I think is going to carry forward, and it just needs some refining. Thank you.
Well, I think I'm up. Thank you so much, Lisa and Ruben, for the great presentation, and thank you to the folks at Northeastern. I guess I should make sure everyone can see me and hear me. Not if you can, great, okay. And thanks to the Center for Health Policy and Law, to Professor Parmet and Jennifer for inviting me to participate. So just to introduce myself, I'm Eric Gold. I'm the chief of the healthcare division at the Massachusetts Attorney General's office. I've been with our office for about 8 years and chief of the division for 3. Before joining the AG's office, I was a litigator in private practice in Boston and Chicago and New York. Before I get into the substance of my remarks, I should just make a disclaimer that the views and opinions that I express here are my own. I'm not speaking for the Massachusetts Attorney General, and my views do not necessarily reflect the views of the Massachusetts Attorney General's office. So as chief of the healthcare division, I oversee our work enforcing the consumer protection laws in the healthcare sector. That means investigating and where necessary litigating against pharmaceutical manufacturers, medical device companies, pharmacies, health insurance companies, hospitals, doctors, dentists, and any other healthcare organizations that have violated our consumer protection laws. Our division sometimes works with our colleagues who handle Medicaid fraud investigations, but we often have separate cases as well. And for many of our investigations and cases, especially the ones involving pharmaceutical manufacturers and medical device companies, we will work closely with our counterparts in other state attorneys general's offices across the country. So I'll start by sharing my experience as an assistant attorney general working with private counsel and public health litigation, then share just a little bit echoing some of the benefits that Lisa and Ruben shared about working with private counsel, and then offer a few concluding perspectives on the proposals that Lisa and Ruben have shared. So our experience, or my experience with the Massachusetts AG's office, is that as far as I know, the office itself has not retained contingency fee private counsel in an enforcement action, certainly since I've been in the office, and I don't think since the tobacco litigation going back to the 1990s. But we do work closely with private outside counsel in at least 3 different contexts, and it's helpful to think about those separately. First, we periodically will hire outside counsel at an hourly or fixed rate in certain cases. We definitely do this where we need to litigate outside of Massachusetts and we need local counsel who we will hire private counsel for. We also will do this where we need counsel who are expert in a specialized area of the law, and we need to gain that expertise. So we do that from time to time as well. We've talked a lot about the opioid cases, and one example where we have hired private outside counsel is in the Purdue bankruptcy. We are, along with a group of other states, being represented by a private bankruptcy counsel out of New York City, who's working with us very closely, and my colleagues are talking with him and his firm nearly every day. The second situation where we work closely with private counsel is where we are either jointly litigating or jointly investigating with other entities that have been retained by private counsel, or that have retained private counsel. These can be other states or other public entities or even private parties where private counsel are involved. And you can see this example in the opioid litigation as well, where our office is investigating and litigating against the opioid manufacturers and distributors and the pharmacies on our own. Again, we're in close contact, working side by side almost every day with the private counsel who represent other state attorneys general, the cities and counties, both in Massachusetts and across the country. And the third place that we work regularly with private counsel in our enforcement cases are in the false claims QTAM cases. And there, the private counsel are generally representing the relators. And although we have not retained the private counsel, we are working often side by side in prosecuting these cases. The False Claims Act provides a structure for the relationship between the state and the state lawyers and the relator. But again, we have frequently investigated and litigated these cases with private lawyers working very closely together. I'll say one of the significant benefits that I see to working with private counsel is what Lisa and Ruben refer to as R&D. We know that private lawyers in all fields are often experts in the legal strategies and the fact development in the particular area of the law that they are working on, whether that's a pharmaceutical marketing case or a hospital billing case. And they can do the same type of case over and over again and build up that expertise. And even a division within an attorney general's office like we have in our healthcare division, our lawyers each work on many different types of cases over the years, different fact patterns, different legal areas. And where there is a new case or new area of the law that needs immediate enforcement attention, we do benefit from consulting with the lawyers on our side of the V who have developed proven strategies in a particular type of case. And that is something that is quite important and quite helpful. I also agree with the points that were made in the presentation that it's very important that success in public health litigation should be measured not just by the amount of money that is paid, but by the impact that the litigation will have on the long-term public health. And I think this is a point that's important both in the relationship with public and private counsel, but also for public counsel acting on their own. Turning back to our work on the opioid litigation, our office has dedicated enormous resources to our lawsuit against Purdue Pharma and its owners, the members of the Sackler family. And we have recognized from the beginning that even though this is a civil claim for money damages, no amount of money will ever compensate for the tens of thousands of lives that have been lost. So in our case, we have been very public that we have two goals ultimately, and that is accountability and transparency, holding Purdue and its owners and executives accountable for their misconduct and making transparent the misconduct that has harmed so many people. This was our goal throughout our state court litigation. And when Purdue filed bankruptcy this past fall in 2019, these were part of the key reasons why our office did not support the proposed settlement. But about half the states were prepared to accept a settlement offer without the transparency that we thought appropriate, without a specific accountability for the company. What's interesting is that in the group that supported the monetary settlement, some were states that were represented by private outside counsel, and some did not have any private counsel at all. And in our group that was thought that there could be a better deal through further negotiations. Some of the states as well have private counsel and some do not. So I think it's important to continue to push all lawyers, private and public, in public health litigation to ensure that the settlements that we achieve are advancing the long-term public health interests. Those are my thoughts, and I thank you so much for inviting me to participate.
Thank you so much to all three of you. It was great to have this fun little triumvirate speak on this topic. Thank you. All right. So last but certainly not least, and actually I think a really wonderful presentation to wrap up this day's discussions with is Peter Jacobson from University of Michigan, who will be talking about Public Health Law 2020, the limits of using litigation to change hearts and minds. And he will be offered commentary from Monica Valdez-Lupi from the de Beaumont Foundation.
Okay, hi everybody. Jennifer, I failed Technology 101.
Sure.
Can you load my slides?
Absolutely.
Thanks. So I want to start off by congratulating Dick on 50 terrific years as a scholar, as a colleague. I really enjoy being with him. It's just a sharp wit, great insight. I always look forward to talking to him. So are my slides up?
Oh, just give me one
Okay.
second. They just accidentally shut down. There we go.
Okay. Well, that was a quick presentation.
All right, here we go. And just let
All
me know when to move on.
Right. So let's go straight to the next slide. Where are we? Okay, yeah. So, sorry, back one. Forward one. Thank you. All right, so aside from being a great colleague, we all know that Dick is a first-rate scholar, but much beyond that, he's a shrewd litigation strategist, an excellent policy analyst, and a policy entrepreneur in the best way, a real advocate. And many of you don't know that Dick and I have had an ongoing debate over the role of litigation in public health law for many years. And he is, as you might expect, quite a worthy adversary. And I'm glad we have the opportunity today to continue the discussion. Next slide. Thanks. So I want to just quickly say, in terms of my thinking in this area, that if we're talking about the role of litigation, we have to ask compared to what? And I think it's important to look at this with the lens of comparative institutional analysis, where we have to think which of the venues would be the most appropriate way of achieving public health outcomes. Is it litigation? Is it the political process? What about markets? And when I talk about markets, as you'll see, I'm also referring to policy entrepreneurs as essentially being a market type arrangement. Next slide. Thanks. So back one. Sorry. So I don't want anyone to misconstrue that I don't find litigation important. I do. It has lots of values, as many of you have already mentioned, but I see it as a complementary or a supporting role, in part countering regulatory and market failures, but also it does bring immediate attention and great visibility. Pardon me, I'm fighting allergies. Welcome to Washington in the spring. Brings high visibility to an issue. As many have noted, the discovery process reveals important supporting documents, motives. Certainly, that was a key to what ultimately was the master settlement agreement. And we've already talked today about tobacco and opioid litigation. And in fairness, it does have the potential to change policy and certainly can provide financial remuneration under appropriate circumstances. Next. But there are important limitations. Lance already talked cogently, as always, about preemption. Forgetting, I know that Michael earlier talked about the Second Amendment, but the First Amendment has been a real barrier to public health policy. Wendy Parmet and I wrote an article several years ago about the pincer movement that the public health officials face, from First Amendment challenges to courts raising the burden of proof on health officials to demonstrate that the regulations should be upheld. And then, as we know, there are lots of limitations to class actions. So even if we think litigation has strengths, it does have certain doctrinal limitations, and as the next slide will show, has certain practical limitations as well. As I said, from an comparative institutional lens, is litigation suitable to all public health issues? And clearly not. Vaccine skepticism. The Flint water crisis emerged as a governmental failure, and as the subsequent litigation suggests, litigation isn't going to result in much change, although in fairness, again, it has resulted in some change, particularly in providing education for special needs kids exposed to excessive lead levels in the water. Opioids, as many of you have mentioned, the jury's still out, as it were, as to whether that's viable, litigation's going to be a viable strategy for changing public health outcomes. The coronavirus, I'm not sure where litigation would fall. I thought I'd just throw that in. We know we're facing a more conservative federal judiciary. So realistically, we're going to be talking about state by state litigation, which has its own share of resource problems. Mr. Gold was saying, that you'll often need private lawyers to handle these cases. Do you have the resources? Can you find pro bono lawyers to take these cases? In the most high profile, probably yes, but not in all cases. And it's unclear what the public health outcomes will be from the litigation. Next slide, please. There are also limits to regulation. We know we're in an era of distrust of government, where there's a shift to personal responsibility as the dominant framing. Micah talked nicely about that earlier, as did, I'm sorry, I forgot, Professor Oliva, I think, talked about that, maybe someone else. There's considerable moral, religious opposition to what public health would like to do as part of the vaccine skepticism. And we know there's considerable denialism, that is, scientifically, people are objecting to the science on a lot of levels. We know how the Trump administration is treating science. Again, the limited resources and the political partisanship has really hurt public health and has made it difficult to overcome some of the interest group opposition. So I'd like to talk a bit about reframing the debate. And here I'm going to pick up, I think, on what a couple people have mentioned. Mark Gottlieb mentioned the public health voice. I want to frame it somewhat differently. And Donna talked about messaging. I think that we need to reframe the debate to build the moral and political case for taking action. That includes building much better messaging strategies from public health advocates, public health professionals, to not just the elected officials, but to the general public. In a sense, trying to change the culture. So as a complement to the tobacco litigation strategy, I think it's clear that the culture changed over time for a variety of reasons, and we need to focus on that. Granted that we like to think of litigation as a shorter term strategy, whereas culture change takes, in some cases, decades, took probably 2 decades or more to change the culture of tobacco regulation. And that's what it's going to take to reinvigorate the public health system. So we need to develop a new political strategy, in my view, to build public support for change and political support. Perhaps we can take advantage of the coronavirus pandemic with its economic, social, and healthcare damage to reinvigorate public health. While I'm not particularly optimistic, at least I think the public is now paying attention. Unlike the bioterrorism threat, where billions of dollars were spent on public health preparedness, it was never about public health. In contrast, the coronavirus is about public health and the infrastructure deficiencies that perhaps can be corrected now. So we have to think about rebuilding the public health infrastructure after the coronavirus. Next slide, please. Thanks. So how do we innovate a public health voice? I'm defining it, and I've done some work with Jeffrey Wasserman, recently retired from the RAND Corporation, on this. And we defined it as the presence of a defined public health message that influences and shapes policy outcomes. Its absence, unfortunately, allows our opponents to frame the debate terms. And I think that was mentioned earlier as well, in a couple of places. So we need a new messaging strategy, which I'll come to in a second. I'm running out of time, so I want to get to that. New advocacy political strategy. And two things on a broader in a broader context can help. One is we need to build more robust state public health associations to coordinate and sustain locally and on a statewide basis the new messaging strategy. And also, I think it would help to consolidate the national public health organizations into one. After all, the Association of Health Insurance Plans was stronger than the two separate public hospital association and private hospital associations were. And the same thing would happen with a consolidation of NACHO, ASTO, APHA, Trust for America's Health, local boards of health, et cetera, et cetera. Next slide, thanks. So to me, the strategy should focus on the legitimacy and the necessity of a robust public health system. That would include what we're seeing now, the economic, social costs of not being prepared for emerging epidemics or much of anything, rebuilding social norms around public health regulation. Now, that gets us into a much deeper dive we don't have time for over the anti-vaxxers, but somehow we need to change the social norms and build a social movement that's sustainable. Okay, next slide, please. So Jean Matthews and colleagues have done some excellent preliminary work on developing new messaging strategies. Jean, a little more than I'm comfortable with, wants to focus it around Jonathan Haidt's moral values. It's not that I don't think moral values are important, but I think it's a little misleading in the way that it's been purveyed. And we just want to speak to the consensus social norms that would appeal to both liberals and conservatives to try to bridge that partisan divide. Here, social media can really become a dominant communications platform. It can be a catalyst for changing organizational roles. And in particular, it's valuable for engaging millennials, since they live on social media. I don't, but I understand the need to build a future movement using social media. Okay, I have 1 minute and only a couple of slides left. Next slide, please. So we want to rethink how public health is communicated, identify 3 to 4 themes for consistency and continuity of messaging, focusing on them. We want to start building this engagement across sectors. The De Beaumont Foundation has a project called Phrases that I think Monica will be talking about in a second, and communicating the value of public health. Okay, last slide, I think. Next slide. Yeah, all right. Public health is political, and public health professionals often lose sight of that. And if we want to build a campaign, it has to be political. We need to generate political commitments from political candidates and elected officials about supporting public health and include them in public health political platforms. I think I'm out of time. I'll just leave it there with a conclusion that for all these reasons, I think litigation is important as a complementary strategy to rebuilding the public health voice and stronger messaging. Thanks a lot.
Thank you so much, Professor Jacobson. It seems like I'm a bit tech challenged here now and trying to get my slide up. Let me just see, Jennifer, if I can do this. Here we go. Let's see. I think I'm standing between all of you and your next Zoom meeting. So I'll try to go through this. Can you hear me okay, Professor Jacobson?
Yes, I can.
Okay, great. So it's Friday, and I wanted to just start with a funny comic here. But I think, Professor, that you did highlight, and again, by way of introduction, I'm the senior fellow at the de Beaumont Foundation, but do have some experience working at the city and the state public health levels, and now working nationally with our partners. And so I definitely appreciated what you ran through in terms of some of the values of litigation, and some of these definitely, when you're working in governmental public health, litigation is certainly a way to raise up the most pressing public health issues, as you pointed out, can also be just the catalyst that we need to get our different constituencies and political bodies and community members to help advocate or organize around important changes that need to happen. And then obviously, I think Professor Daynard had mentioned this, that sometimes, like the master settlement, some of those dollars end up going into the general fund, but hopefully litigation can help in terms of driving much needed compensation and resources to those who need it the most, those who've been impacted by some of these issues that you talked about. And I also appreciate how you talk through in your slides the practical limitations of both litigation and regulation for tackling all of these different challenges that we're experiencing on the government or the public sector side of the public health enterprise. When I was thinking about some of the limitations that you had flagged regarding timing, I was thinking about Flint. And it's hard to believe that it's been 5 years since that first lawsuit was filed against the city. And in the last 5 years that it's been making its way through the legal process, the city has had to deal with the Legionnaire's disease outbreak in 2017 that led to deaths of, I think, 12 people. And so definitely that is a practical limitation. I also think that there are also often competing public health crises and priorities. I mean, I think your short list was a very weighty list of challenges, and sometimes, and I think on the government side, that often leads to the last bullet, which is the resource constraints with staff and funding. When I think about some of the work that I did at the city and with Donna at the state health department, on the regulatory side, using that as a policy lever for tackling public health issues, certainly what we often confronted was this notion of the nanny state versus personal responsibility. And so I think these are ongoing challenges in that regulatory space. I would like, I'll get to the kind of the reframing, because I do think there might be an opportunity on vaccinations with COVID-19, but I'll come back to that. I also think you talked about messaging and effective messaging using different social media platforms and trying to tailor the message. And I think that this remains a challenge in multiple domains of public health when we're trying to create the narrative. And I see it now when we hear public health, that phrase being bandied about in the COVID-19 response, and the images that we see are often doctors and nurses, and not your epidemiologists or your data analyst staff or your contact tracers at the health department. So I think that is also a limitation that we face on the government side. Resource constraints, I think, also exist on the regulatory space, and I'm not sure if someone had mentioned it yet, but I know in working with other state health departments, we were very fortunate in Massachusetts to have Donna and what was basically a boutique law firm of attorneys who were assigned to different programmatic areas and had very much programmatic subject matter expertise that was invaluable to those who are actually delivering the services. But the reality is that that's not the norm out there for state health departments, who often have maybe one attorney, maybe two, that are assigned from their attorney general's offices to support all issues, not just one. And then I think you alluded to this in terms of the political context. And I often called it with my staff the shiny object syndrome. So very distractible in terms of your political context, sometimes your own board, your elected officials. And for us, I know who work in governmental public health, sometimes even despite the desire to move forward on different policies and regulations, being caught betwixt and between election cycles. So I really, when you were talking through your presentation, and what excited me was the optimism that you had in terms of how to reframe the debate. And we've talked about this in the other sessions this afternoon, about this window of opportunity with COVID. I already talked about social media, but I wonder, with different policy and advocacy perspectives, that people are really paying a lot more attention now as compared to post 9/11 bioterrorism emergency preparedness funds that flowed and worked to shore up security. We now have a very wide range of very diverse constituents that I think could be organized around public health concerns, like social determinants of health and the social conditions that our communities live in. So when it comes to paid leave, housing, food insecurity, what we're seeing in terms of school closures and the digital divide and lack of access to equipment that many of our communities are grappling with. And I mentioned vaccines and this nanny state challenge. And I wonder if we could now start to work around, as you say, rebuilding social norms around public health regulations regarding vaccines, because I hear so many people just around me, family members, and then colleagues, who keep focusing on social distancing, stay at home, and feeling concerned about returning to work unless there is a vaccine. Whoops. And then the last one is really what you talked about with crafting powerful messages. What happened there? So let me just try to do this. Crafting powerful messages. So I appreciate that you mentioned the de Beaumont Foundation's initiative or project with phrases. And I wanted to bring up two more examples that are definitely relevant. The one is hashtag Why Public Health Matters. So I hope all our professors and others who might be listening will go to this website and consider taping. It only takes 1 minute, and I'm tech challenged, but I managed to do it to really amplify why public health matters now. And then another hat I wear is with our CDC Foundation, which is trying to do a lot of crowdfunding to get resources to mobilize for action on the ground across the country. I'll just close, Professor Jacobson, with the one bullet that you had made me a little nervous, having worked at a national organization, membership organization, ASTHO, and now working with the de Beaumont Foundation and Big Cities Health Coalition. I do wonder, I do think that would be a lightning rod, what you propose in terms of consolidating our national public health organizations, though some days I feel like that would be a more simplified structure. But wonder if each of them has a distinct role to play, given the absence of leadership at the federal level and because our public health enterprise is so fragmented. So I really appreciate the chance to review and to learn from what you've presented today, and really appreciated that we're hopefully ending this discussion on a really happy, optimistic note for the future of our public health.
Thank you.
Thank you so very much to you both. I think that's a great way to end things. Before we officially end, I do just want to say thank you so very much to all of our speakers, our commentators, everybody who was involved in making this happen. The law review, wonderful research assistant Cassandra, who was wonderful in helping us manage everything, Siobhan Fanning, for keeping things together on the tech side. And of course, our faculty director, Wendy Parmet, as well. Give me one moment. There we go. Oh, did it work? Oh, for some reason, it's not unmuting.
Hi, I just want to thank Jennifer again, who has done an amazing job pulling all this together and making this virtual conference such a great success. I also want to thank all of our speakers and commentators. Your papers and comments were great. I look forward to reading all the papers in the law review. And I look forward and will try to remain optimistic that we will see you all at our spring conference next spring. Stay well, stay healthy, stay home. And we will be together again soon. Thank you.
Absolutely. Just a reminder, you can visit our website as well as the Northeastern channel, YouTube channel, to watch this video and visit our website for more information and to see the papers that will be published after this symposium later this year. Thanks so much, everybody. Stay well. Thank you. Thank you.
Thank you.
Bye.
Bye. Jennifer?